We are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and welcome to the March 2nd sitting of the Massachusetts Appeals Court. My name is Mary Thomas Sullivan, and your panel today will consist of me, Justice Kenneth Desmond, and Justice Sabita Singh. All the usual rules of oral argument apply in this remote format. That is 15 minutes per side, no reply. Feel free to get to the heart of your argument. You may assume that we are familiar with your case and have read your briefs. From time to time, and I mention this to the people who may be watching in our virtual audience, we may have technical issues. We will do our best to resolve them expeditiously. But you may see us go offline for a moment in order to do so. Please be patient. We will return. Hopefully there will be none, but sometimes there are. And also, by the way, if either the parties or those of you watching see us look away momentarily, please don't take that as a sign of disrespect or inattention. We, in fact, have all of our case materials either in paper or on iPads near us. And sometimes in order to be able to ask our next question or verify what's in the record, we look away for a moment. But you have our full attention. And with that, I will call the first case, which is number 20P0078, Commonwealth versus, is the correct pronunciation, Lee?
Yes.
Okay, thank you. Attorney O'Mara Costello, you may proceed.
Good morning, and thank you, Your Honor. My name's Ruth O'Mara Costello. I represent Mr. Lee. And this is a case where Mr. Lee's statement to police, which came in at trial through the testimony of the responding officer, conflicted with the testimony of one of the alleged victims who testified at trial in a number of ways, which raised questions about self-defense and also about whether the knife that he had allegedly had in his hand during the incident qualified as a dangerous weapon under the law. The jury here was not instructed at all on self-defense, and the judge instructed the jury that as a matter of law, a knife is a dangerous weapon without regard to conflicts in the testimony about what kind of knife he might have had, where he gave a very different description of it. And so taken together and in the context of the trial as a whole, the instructions deprived the jury of the legal context that they needed to be able to understand what factual conflicts they actually needed to resolve to reach a verdict, and what the legal significance of those conflicts was.
So Attorney O'Mara Costello, so there was no request for self-defense instruction, is that right?
That's right, there was not.
And that's because the defense attorney's theory of the case was this was really kind of a silly dispute amongst brothers and didn't really rise to the level of a criminal act. Was that more or less the theory of the case?
Well, she certainly argued in her closing that this was a silly dispute between brothers. Maybe not using the word silly, but she said this was, brothers fight. This was just a dispute that escalated to the level of someone calling the police. She also said that she believed that there had been an incident which appeared to include a belief that there was a physical confrontation and clash between the brothers. And so I mean, to the extent that there was a theory of the case here, and obviously one of the issues that I've raised is ineffective assistance of counsel in the failure to request an instruction on self-defense. It's not clear whether it was self-defense or whether it was that the physical confrontation just didn't happen, because it seemed like in closing she was conceding that the physical confrontation did happen, which would seem to mean that she was conceding that there was at a minimum an assault and battery.
And your client admitted in his statement to the police officer that he had some type of a knife in his hand. He says it was a plastic knife, although there's no other description from him. Is that right?
That is right. To the extent that there is another description, the description, I mean, I think that where he says that he flushed the knife down the toilet and that he, quote unquote, destroyed evidence, I think that if you draw inferences in his favor, as you would for purposes of determining what instructions he was entitled to, there's an inference there that it was a fairly flimsy knife. The alleged victim, Sebastian McCarthy, who testified at trial, was describing a knife with about a 12-inch blade. At some point, he says that it had a steel handle.
I understand, but your client didn't describe the knife in any other way other than by saying it was a plastic knife. Is that right?
And also describing that he was able to flush it down the toilet. I think that that is a description of what the knife, of characteristics that the knife must have had, that it was capable of that. But yes, that's all.
Could you review for me what evidence gave rise to the self-defense instruction?
So my client's statement to the police when they arrived and prior to his arrest was that that the two alleged victims had been arguing, that he had gone in and asked them to be quieter, and that Mr. McCarthy, who was the testifying victim, had then challenged him to go outside and fight. And at that point, he said that he started to go outside with Mr. McCarthy, that Mr. McCarthy then ran away, and Jackson instead jumped, his brother Jackson, who was also present, then jumped on his back. And so I recognize that there's an issue concerning his acceptance of the invitation to fight. What I would argue is that the point that his brother attacked him from behind, that's an unforeseen circumstance that changes the nature of the invitation that he accepted, such that he would be entitled to a self-defense instruction.
And so that being said, when he was invited to fight, if you believe his story, that he was invited to fight by Sebastian McCarthy outside, a fist fight, I think is his words, he went outside with a knife.
He went out, I mean, he said what he said to the officer, and his statement is fairly brief as it came into the record, was that he had a plastic knife in his hand.
So he went outside with the knife. Am I saying something different than you?
No, Your Honor, I think that is what he told the officer. His testimony, his statement rather, didn't say anything about why he had the knife, where the knife came from, but I would assume that, yes, he took it from inside to outside.
Sure. And when the police arrived, they knocked on the door. I think the officer testified nobody answered the door at first. He went back and spoke with the alleged victims. And then when backup arrived, he went and knocked on the door again, at which point your client answered the door. And I believe it was in that exchange that your client said he flushed the evidence down the toilet. Is that right also?
That's right also. I think that Mr. McCarthy's testimony was that he yelled at the defendant who went back inside the house. And I think that the police, yes, that's right.
Will you talk a little bit about, I don't mean to cut you off. Will you talk a little bit about the conditions of probation? Let's talk about the order to remain drug and alcohol free. Was there any evidence at all in this case that drug and alcohol played a part?
There was no evidence at all in this case that drug and alcohol played a part. So in the testimony at trial, this was an incident that took place, during the day. There was no testimony that this was following a party or following any occasion where you could even infer that drugs or alcohol might have been present. There was no testimony that my client had been using drugs or alcohol, and no testimony that he appeared to be under the influence of any kind of substance during this incident.
Was there evidence at the sentencing, or was there information provided at the sentencing hearing regarding past problems with drugs or alcohol?
So the only thing that came up at sentencing was that, and I want to note that the Commonwealth asked only for a substance abuse evaluation. They weren't asking for the condition that the court ultimately imposed. And in asking for that, the Commonwealth said that the two alleged victims had told the prosecutor that sometimes Mr. Lee had had parties at which they believed that hard drugs of some kind were present. They said specifically that they didn't know of whether Mr. Lee had himself used those drugs, but that those were occasions that had happened. That was the only basis that was offered at sentencing for the imposition of the condition, which again was not just an evaluation, but was a condition that Mr. Lee remain drug and alcohol free, and also that he submit to random testing, which is why there's a constitutional dimension to the issue. Also, in that there's a constitutional search happening every time he has to submit to that random testing.
But he didn't argue that, or maybe he did, but I didn't see it on his motion to revise and revoke. In the motion to revise and revoke, I believe he asserted that it was an inconvenience to him because it disrupted his workday.
He did assert that, but he also asserted that there was no basis in the record essentially to support the condition.
Okay.
If the judge had ordered only an evaluation, and if the evaluation were returned saying, yes, there are anger management issues, and they are largely triggered by, name it, drugs or alcohol, would the judge have been permitted to add an additional term of probation at that point, or was the judge required to add it at the outset subject to a subsequent request that the defendant be relieved of that condition?
I mean, I think that it would depend on how the judge framed the conditions at sentencing. I wouldn't ordinarily think that the judge would be free to go back absent some violation and simply add on new conditions. That said, it's certainly fairly common that a judge would ask for a substance abuse evaluation and put some sort of condition in the language of sentencing, to comply with recommendations for treatment, or to otherwise, comply with recommendations coming out of some sort of evaluation.
So if that's permissible, why is it not permissible for the judge, perhaps in an excess of caution, there being some basis for requesting the evaluation, to impose the condition immediately? No, and the defendant would be entitled, if he got a favorable report from the evaluation, to come back and ask to be relieved of that condition, would he not? Or am I could be wrong. Tell me.
Well, I think that the defendant could certainly come back and ask to be relieved of the condition. But I think I'm not conceding that there was necessarily a basis for a substance abuse evaluation here in the first place. There plainly was a basis for anger management, which was imposed as a condition. And I believe there was also a psychological evaluation, which he's completed. But I don't, the defense at sentencing took the position, and I would take the position now, that there wasn't a basis for an evaluation in the first place, where the only evidence at all is in the record that of any use of drugs and alcohol is of there being drugs and alcohol present at parties. So I would say that, and then I think that the second thing I would say is that I don't think that in an abundance of caution you can impose a condition that involves a constitutional search and seizure for which there's not yet a basis. And so I do think that there's a difference between saying we're going to do an evaluation and then we're going to impose the condition, and then you'll follow the recommendations coming out of that evaluation, versus saying we're just going to impose the conditions now without knowing that we have the basis that we might learn that we have through the evaluation process.
So I follow that. I get that. So indeed, as you've already said, the Commonwealth requested that he have a mental health evaluation and any treatment that's deemed necessary. And I believe they also asked for drug and alcohol evaluation and any treatment that's deemed necessary. And you just said, I think, that you concede that perhaps there was some grounds for a psychological evaluation based, I'm assuming, based on the conduct or the actions in this incident in and of itself. The arguing over something which seemed not a very big deal, going outside with or without a plastic knife, arguably kicking the door in or whatever happened to the bedroom door. So wouldn't that warrant perhaps a drug evaluation? And maybe it wasn't mental health. Maybe he was under the influence of some drugs. How do we know?
Well, again, I think that if you look at the Gomes decision that I've cited in my brief, there really needs to be, where you're asking for testing, there needs to be some basis to believe that he's ever used drugs and alcohol, and there really isn't here. I don't think that in every case where there's some violent action or some action that seems unstable, which is going to be a lot of cases, absent some indication of the involvement of drugs or alcohol, either in the defendant's history or as a motivation for the conduct, I think that you're opening it up for basically every case to involve a possible substance abuse evaluation. I do want to very quickly focus on the instruction about where the court instructed the jury that as a matter of law, a knife is a dangerous weapon. In that I think that the law on that is pretty clear that that's an erroneous instruction under these circumstances where there's an actual dispute about the knife. And there are a number of cases that, as the Commonwealth noted, hold that where there are severe stab wounds, it's essentially immaterial in that the knife was obviously used in a dangerous fashion. And I want to note that this wasn't that case, that the only injury was superficial. And so there's very few ABDW cases that raise that issue, but I want to note that this is one and that I think it's a potentially significant issue.
All right. Well, it looks as though your time has expired.
I have one more question, if that's okay, Justice Sullivan.
Of course, I was just going to ask.
It's two parts. One is the victim of the assault and battery dangerous weapon was the defendant's brother, not a very common scenario either. And two, why do you think he flushed the evidence, in his words?
So as to the first part, yes, the victim was his brother, which is not a very common scenario, but certainly it's not uncommon to see some sort of, you certainly see ABDW cases with family members or household members. And so I think that this is more or less analogous to those kinds of situations. Why do I think he flushed the evidence? I mean, that I don't think that I can speak to, and I don't think that the record reflects what his reasoning was. Presumably the Commonwealth admitted the evidence for an inference of consciousness of guilt, but I don't think that there was an instruction to that effect. And so I don't know that I can say more about what his intention was.
Thank you.
Are there any other questions from the panel? All right.
All right, thank you.
Thank you. Attorney Cusick.
Thank you, Your Honors. Good morning. Tracy Cusick on behalf of the Commonwealth. Your Honors, the Commonwealth is asking this court to affirm the convictions here for assault with a dangerous weapon and assault and battery with a dangerous weapon, and also the denial of the motion to revise and revoke seeking to modify the conditions of probation pertaining to being alcohol and drug-free and random testing. Your Honors.
Will you start there? Why should he be subject to alcohol and drug testing and random testing? Why? Without any evaluation, how is that even in this case?
Your Honor, at the sentencing, the Commonwealth did inform the judge that the brother had said that the defendant hosted parties where hard drugs were present and asked for an evaluation, for substance abuse evaluation. The judge also imposed mental health evaluation and anger management, and certainly the connection between the use of drug and alcohol and anger management problems and mental health problems are well established. So I suggest here it was permissible to impose the condition at.
Why? I'm not following you. Why? What's the nexus to testing for drugs and alcohol other than he had a party where hard drugs were present, and that doesn't even suggest he was using them?
Your Honor, I'd suggest having a party where hard drugs are present. I guess one can draw several inferences from it, but I'd suggest that the inference that the court could draw is that he was using the hard drugs, that you wouldn't have that type of a party if you weren't participating in the use of the drugs at the party. And here the defendant's behavior was highly unusual. The banging on the walls in the bathroom, which sort of apparently precipitated the whole incident, but the testimony that it was not an infrequent occurrence, just usually directed at the neighbors rather than at the household members.
But isn't it telling here that the Commonwealth itself only requested an evaluation?
I think it's telling as to what the Commonwealth requested, but again, the judge certainly had the ability to not adopt the Commonwealth's request or suggestion and chose to do something else. And I suggest that what the judge did choose to do was appropriate. It may not have been what the Commonwealth requested or what the defense requested, but the judge gets to decide what the conditions are. And I suggest here the decision was within the judge's range of options.
Well, the judge doesn't just get to decide what the conditions are without some grounds for him, right?
Right. The judge certainly needs grounds, and I'd suggest the grounds were present in this case with, again, the information about hosting parties with hard drugs. Again, hard drugs presumably are not legal drugs, so it's not a party where there's some sort of drug that might be legal being used or
But
legal.
even with that description given, hosted parties where hard drugs were present, I mean, that could mean people coming to the party who brought these things. I mean, that's not even suggesting that he provided them for people. I mean, he hosted, I'm not sure how many. I mean, you know, it seems like very, very thin basis to suggest that from the fact that there may have been hard drugs at a party to the fact to make the inference that he consumed, to make the inference that he's now got a problem with it that is related to this criminal behavior or this incident. Those are a lot of inferential steps to get to complete abstinence from drugs and alcohol and random testing.
I agree, Your Honor. It's many steps to get there, but I suggest here it was permissible for the judge to order this. Again, in light of the behavior for which the defendant was convicted and in light of the anger management problems that were demonstrated in the case and the apparent mental health problems.
But even on all of those issues, evaluations were ordered, weren't they?
They were requested. I don't know that the judge ordered them. I'm sorry, I'm drawing a blank on the record.
I'm thinking about the situation where, let's say, a criminal scenario may indicate that there may be anger issues or maybe psychological issues, but would a judge be within their discretion to indicate that you must go to individual therapy once a week and in essence, dictating the type of therapy that's necessary without any sort of evaluation to determine what's appropriate?
That's a hard one. I mean, I guess because therapy has a variety of different forms that it takes and a variety of different things that people find helpful that other people might not find helpful. So I guess it maybe, depending on the scenario, I believe there are some cases where a judge orders a person to attend AA or Narcotics Anonymous or something like that, which is almost a hybrid form of therapy that helps a person not use certain substances. So depending on the facts, there may be some cases where a judge could order that, and perhaps there's some where a judge would not be able to order that.
Would the judge have been warranted in ordering this defendant to go to AA?
I don't know, Your Honor. I guess there was nothing in the record that anybody thought to recommend AA or that the defendant had previously participated in any way, shape, or form. So I don't know, Your Honor. I hadn't really thought it through. I would think probably not, but I haven't given that particular question a lot of thought other than right now. So I apologize for not having a better answer.
That's okay.
Your Honors, with respect to the convictions for the self-defense claim, the defendant didn't request an instruction on self-defense, wasn't entitled to one, and certainly the judge not giving one sua sponte did not create a substantial risk of a miscarriage of justice. Here, the defendant's own statement indicated that he accepted an invitation to a fist fight and that he had to leave the house to go to this fist fight. So suggest right there the defendant is not taking the steps necessary to avoid combat, such as staying in the house. And then also the defendant indicates he had a plastic knife in his hand when he went to this, and he chose to share that detail with the police. So I suggest that that's significant also. But certainly the facts of this case did not entitle him to a self-defense instruction. Had he requested one, I believe it would have been denied. But even if the judge had been persuaded to give a self-defense instruction, it wouldn't have been particularly helpful to the defendant in the circumstances where the assault with the dangerous weapon offense that was completed as the defendant came out of the house with the knife and Mr. McCarthy then ran. So that offense was certainly completed. And looking at the evidence where the defendant had the testimony that the defendant had a knife to his brother's neck and the brother was protecting it with his hand and blood was drawn, that certainly what the defendant did was not proportional, even if a self-defense instruction had been given, proportional to the threat that was perceived. So certainly I'd suggest that there was no issue of any substantial risk of a miscarriage of justice without that instruction. Certainly trial counsel, we don't have a motion for new trial, so we don't know exactly what her strategy was, but in this case, she had many things to contend with, including McCarthy's testimony about his perception of the events, but also the defendant's statement to police indicating that he went outside to fight somebody. So I would suggest that counsel was not ineffective for using the strategy she did use in this case.
Given the plastic knife evidence, wasn't the judge wrong to instruct on per se?
Yes, Your Honor. The judge should have instructed not the per se instruction, but the dangerous as used. But I'd suggest here it did not create a substantial risk of a miscarriage of justice. The evidence of the knife was that the defendant brought it out of the house with him. And there's testimony from McCarthy that he perceived it to be a butcher knife, a big kitchen knife, and that it was held to the brother's throat. So certainly this was a knife that was used in a dangerous fashion exclusively. Not a case where it was, part of somebody's lunchbox, a utility knife in somebody's pocket, and they happen to be arrested for something and it's found on their person.
Well, from the defendant's viewpoint, wasn't his statement that he happened to have a plastic knife in his hand as he walked out the door?
That was his statement. Now, when looking at the knife and at the instruction about the per se dangerous weapon or dangerous as used, the defendant at least acknowledges he has something in his hand. And looking at the other evidence, the testimony is what he was doing with that item in his hand. And it being plastic does not require an inference that it's, I'm visualizing that the defense is suggesting it's the kind of plastic knife you get when you get takeout food. And I suggest that that inference is not required because there's many sturdy plastic knives. Not all knives are metal, most are, but craft knives, utility knives, there's many types of knives that can be made out of plastic and still be something that can inflict a grievous bodily injury.
Wasn't the testimony, and correct me if I'm wrong, that Mr. Sebastian McCarthy was at the bottom of the stairs and the defendant was at the top of the stairs when he started coming down the stairs with the knife and Mr. Sebastian ran out of the house?
That's my recollection, that Mr. McCarthy then ran and fell down some stairs and over a wall, that he fled, but the defendant was coming down the stairs with a knife, and that was what caused him to start running.
I guess from the defendant's perspective, we don't really have much of a story as to how the knife was used at all. Just they had
Yes,
it.
the defendant's statement to police was very limited about it, but it was significant to the Commonwealth's case because he does acknowledge having a knife in his hand and does acknowledge that he went outside coming, just to engage in a conflict with Mr. McCarthy.
And indeed acknowledges flushing the evidence.
Well, that's what he claims happened to the evidence when he spoke to police. That's what he claims he did with the evidence. If there were no further questions, I would rest on my brief.
Panel?
I'm all set, thank you.
All right. Seeing none, thank you both very much. And spring is upon us, and we hope that the balance of 2021 is a healthy and safe year for you both.
We are live.
Thank you. Good morning, everyone, and welcome to the March 2nd sitting of the Massachusetts Appeals Court. My name is Mary Thomas Sullivan. Your panel today will consist of me, Justice Desmond, and Justice Singh. The usual rules of oral argument apply. There are 15 minutes for each side. There is no rebuttal. We encourage you to get to the heart of your argument. You can assume that we have read your briefs with care. To those of you watching, we hope that we will have no technical issues. We do have a timing delay for one of us, so you may hear a voice before you see the screen catch up. If there's anything more serious, we will do our best to fix it and to make sure that everybody gets their 15 minutes. But we may have to go offline for a moment in order to do so. So if your screen goes dark, please be patient. We will be back. And finally, if you happen to see any one of us look away momentarily, please, it's no sign of disrespect. We simply have our other case materials, our briefs and our transcripts and the like to one side of our or another, and we're referring to them during the course of oral argument. So without further ado, the next case is 20P0702, Commonwealth versus a juvenile. I'll remind the parties that we are using pseudonyms as the case involves a juvenile. And I would also encourage you to use pseudonyms for any other witnesses as well. Thank you very much, and you may proceed. Attorney Carleen.
Good morning, Margaret Carleen on behalf of the juvenile. Before I begin, I wanted to point out that the applicable standard of review for the vouching issue is incorrect in the brief. The Commonwealth is correct that the applicable standard is prejudicial error. The analysis in the brief, though, does follow the correct standard, and the issue is analyzed under the correct standard. The issue of intent was important in this case and went to the heart of the defense. All of the errors that occurred in this case at trial surrounded the very point that was most an issue in this case, whether the juvenile had the requisite intent to commit a crime. The major issue in the case was whether the juvenile hit the alleged victim intentionally or whether he was trying to free himself and get away from her and accidentally made the contact. The errors in the case compounded because they all concerned this same issue of intent. First, the prosecutor misstated the testimony of the only third-party witness that testified in the case and completely changed the essence of her testimony, and that testimony went to the intent issue. Then the prosecutor impermissibly vouched for that very same testimony right after she misstated it. And then the judge gave incorrect jury instructions on the same issue of intent. These instructions have been considered under the case law, quote, unnecessary and confusing. And these incorrect instructions were repeated twice, first at the final charge, and then on the second day of trial before the jury resumed deliberations after they had asked to have them repeated. And the jury was obviously confused about the issue of intent, and they didn't understand what they were to decide. This was the harm to the juvenile was obviated when they asked a question on this very same issue of intent again. The question was, does intent mean to harm or intent to put the hands on a person? As to the first problem,
Attorney Carlene, was a video entered into evidence in this trial?
There was a video. There was a video entered into evidence.
And what's the video?
The video depicted the two.
Sorry for my delay.
I apologize. The video depicted the two speaking in the hallway. It was dark and they were far away, but when the alleged, there was a contact, there's no question about that, but when the contact occurred, they were standing behind a column, so it's not clear from the video what happened.
But the fact finder is able to see what was going on immediately preceding the alleged accident and what happened immediately after?
That's correct. Immediately before the impact, the victim, and she admitted to this in her testimony, was blocking the juvenile's path, getting in his way, using her body to make sure that or attempt to not let him walk away. Immediately after the impact, you could see her head go back and her sunglasses came off. And then she ran after him as he exited the building.
And then there's the incident outside the building. That's
right. So after
So my question is, what is your understanding that the charge says March 13th? Do you have an understanding as to which of those events was being charged in this case?
Yes, both of those events were the March 13th incident. There was another alleged incident on March 4th, but there was a not guilty finding.
That I had as well. So, but there's only, correct me if I'm wrong, I went back and rechecked. There's only one charge, correct? There's only one complaint.
There were two separate, that's correct. One complaint, that is correct.
All right. So in your view, of which of those events was your client convicted? The incident in the hallway or the incident outside?
The March 13th events, the two incidents outside and in the hallway were seen as one event, and he was convicted.
Okay.
As to the first problem, I'm sorry, Your Honor.
No, go ahead.
As to the first problem, the juvenile had testified that the alleged victim put her hand on his shoulder in an attempt to get him to turn around and pay more attention to her. He did not intend to actually touch her, but when he lifted his arm and turned to get her hand off of his shoulder, they made contact. There was a teacher that saw them together, but she did not see the entire interaction, and she did not see the important parts of the interaction between them. When they made the contact, they were standing behind a fence. But the prosecutor improperly foreclosed the juvenile's defense by changing the teacher's testimony and misstating it, making affirmative statements about what she saw.
Well, is it fair to say that nobody saw what happened behind the pole and that both sides are asking the jury to draw an inference from what preceded and what came after?
Well, but an inference needs to be permissible, and what the prosecutor had stated was an impermissible inference that was contradicted by the record.
Why is it leaving aside how the prosecutor argued it for a moment, I just want to talk about what a permissible inference is. There are things that the witness saw happen. There's the pole that obstructs the view, and then there's what came afterwards. Is it a permissible inference, in your view, that the defendant struck the young woman in the moment that they couldn't be seen?
I think it would be seen more as an issue of credibility, because she said she denied putting her hand on the shoulder, and he said she did. So I don't think the jury would even need to make an inference. I think they would need to decide who they would believe.
they wouldn't need to make the inference in order to acquit the defendant. I'm asking a different question, which is, since no one could see exactly what happened, and she has testified to a certain version of events, is it permissible for the jury to conclude that he struck her on purpose while the view was obstructed?
I'm not sure that such an inference would be reasonable, because we have evidence that she chased him, blocked his path, and tried to pull him around to get him to pay attention to her. So I'm not sure that inference would be reasonable based on this record.
Well, I don't know. Maybe he struck her because she chased him and pulled him around and didn't want to let him go.
I suppose the question would be whether that's reasonable. So I suppose reasonable minds could differ on that.
All right. So, but you want the jury to draw the conclusion that in that moment that they couldn't be seen, that there was an accidental touching, right?
Well, yes, and to credit the juvenile's testimony.
Right.
But the issue.
So no one knows. We can debate what was a reasonable inference and what wasn't. What did the prosecutor do that was more than arguing what the prosecution's view was of the reasonable inference to be drawn from the evidence? What did the prosecutor say or do that crossed the line?
What she said appears on page 154 of the transcript, day one. She said, the teacher told you that she saw their hands down by their side. She saw that flash of movement and the alleged victim's hand come up to touch her nose. She did not see the alleged victim's hand up on his shoulder. She saw them down at her sides and then come up to stop the bleeding. This is a misstatement because such a statement is squarely contradicted by the record. The teacher testified that she could not see what had transpired between the fence, and that's when the contact occurred.
Is the prosecutor saying that she saw it, or is the prosecutor asking the jury to draw that inference?
A person hearing that will think that the teacher actually testified that she didn't see the hand when she changed the facts of the hand position of the victim. And there is case law that that it has to be drawn from the evidence. It has to be possible. And here it's not possible that she saw that. The testimony was also sort of confusing and vague, as the Commonwealth concedes. It consisted of hand gestures and very unclear. So it posed a particular problem for the prosecutor to do this, particularly when a prosecutor is held to a higher standard in evaluating the propriety of statements made in closing argument.
So it sounds like your main issue is with that statement that the teacher didn't see the hand on the shoulder, and arguing it as if it was an affirmative statement. No, I did not see that hand on the shoulder, when in fact it was sort of an absence of seeing anything during a particular time period.
That's right, but I think the first sentence may have been okay, but when she said, I didn't see the hand on the shoulder and she saw them down on her, it's these three sentences together and the context of them that created a misstatement of the evidence.
So according to the way the prosecutor is sort of relaying relaying the testimony of the teacher, it mirrors the victim's testimony of what happened when in fact the teacher didn't see critical portions of it.
It doesn't exactly mirror it, but it certainly supports that view. I think the alleged victim simply denied putting the hand on the shoulder, but she supplied information about hand positions, which was not in the record.
Doesn't the Commonwealth argue, and I can't recall whether it was in closing or whether it was an opening, that the witness teacher didn't see the actual strike? Doesn't the Commonwealth say that?
Attorney,
I apologize. I didn't hear the question because the video and sound froze.
Okay, the question was, didn't the prosecutor say at another point in the argument, or did the prosecutor say at another point in the argument that the teacher hadn't seen the whole thing?
I'm not sure that that appeared, that she indicated that she didn't see the whole thing. She seemed to contradict herself in that case, because then she said that she did. That she didn't see the hands down by the sides, and she didn't see the hand on the shoulder.
But doesn't the prosecutor say that the witness did not see the actual strike to the alleged victim's face?
Even if she, but even if she did, it's the changing of the hand positions,
But
which
that,
went
not even if she did, not even if she did, not even if she did she say that? Did the Commonwealth say that?
I don't recall seeing that in the I don't recall seeing her say that in the transcript. But the jury was likely to believe that the prosecutor, as a representative of the government, was accurately summarizing the evidence for them. And it was particularly a problem where the evidence wasn't clear. So this alone posed a substantial miscarriage of justice, but that's particularly so when it's merged with the other problems concerning the intent issues in this case. Immediately after she made the misstatement, the prosecutor then impermissibly vouched for the very same testimony. The case law is clear that vouching is only permissible when defense counsel puts the issue, places this in the credibility of the witness in issue first. The defense counsel's clarification of what she told police and what she saw would not constitute putting this into issue. And there's case law on that very point to support that proposition. The standard here is prejudicial error because defense counsel not only timely objected, but he also filed a motion in limine on the issue, which the court allowed. There was no curative instruction given, even though defense counsel objected. And this was prejudicial because the testimony wasn't even accurate, and it's certainly the jury's province to decide the credibility of witnesses. Finally, the judge's unnecessary and confusing jury instructions also served to create a substantial risk of justice. The instructions were given twice, first at the final charge, and then again on the second day, because they had asked them to have them read again. They were obviously confused. They returned an hour later with 2 questions, asking to have the elements of the crime repeated, and then asking, does the question about intent again, does intent mean to harm or intent to put the hands on a person? And the curative instructions did not solve the problem because first, the harm had already been injected by the confusing instructions being read twice. And the specific instruction concerning the accident defense was not repeated, so that it was not highlighted for the jury the differences between an intentional act and an accidental act. The case law is also clear that where there's a legally recognized excuse or justification in an assault and battery case, the jury should be instructed with the specific accident instructions, and that's the Wood case, 90 Mass Appellate Court 271, page 286 to 88, 2016. So given all of their confusion, it seems unlikely that the accident instructions would have remained in their minds. There are cases that say that the risk of jury confusion can be neutralized if the judge gives clear and emphatic instructions or if the Commonwealth's case is overwhelming. But here,
counsel, your time has expired. Counsel, would you like to wrap up?
Yes, just one more sentence. Here, this is a very nuanced interaction, so the evidence was less than overwhelming, and these instructions were not clear and emphatic. So for these reasons, if the standard is prejudicial error because of the cumulative effect of these problems, the juvenile meets that, but even under the higher standard, each of these problems alone created a substantial risk. Thank you.
Thank you. Were there any more questions from the panel? Okay. Seeing none, thank you. Attorney Yang.
Good morning, may it please the court. Kristen Zhang for the Commonwealth. Taking these issues one by one, unless there are questions from the court to direct me to one or the other. The first issue, the Commonwealth submits that the prosecutor did not misstate the evidence in her closing argument. For all of the reasons that I summarized in my brief, I believe her recounting was consistent with the testimony here. The teacher clearly testified that she observed both parties walking together with their arms down. You can see from the photographs submitted as exhibits at trial that there wasn't a lot of the point where she saw those hands down at the sides was not far from the point of contact or the assault that occurred in this case. So it was a reasonable inference that the arms of both the juvenile and the victim remained at their sides the entire time. Regardless, there was no substantial risk of miscarriage of justice here. The jury was properly instructed. And also, I don't believe that the placement.
If you would go back to that first argument for a moment, the prosecutor does not say, the prosecutor summarizes what the prosecutor would like the jury to conclude, but this is a sins of omission case. He omits the fact that that the witness did not see what occurred at that point. Is that a material misstatement?
I don't believe so. I'm sorry, I didn't mean to interrupt. I don't believe it was a material misstatement. Given the evidence here, the jury was well within its right to credit the victim's testimony and to discredit the juvenile's testimony.
That's a different
Sure.
issue. I'm talking about the discrete issue raised by the defendant as to whether or not the prosecutor misstated the evidence when she summarized what the witness saw. And by omitting the fact that her view was obstructed at a critical point, is that a material misstatement? And what is your best legal case from our court or the SJC for the proposition that that is not?
So I don't think it is. And if you look specifically at the part of the testimony where she describes how long her view was obstructed, she says only for a second. So I don't believe that's critical.
Second, though, isn't it?
It was a critical second, but she saw right before and right after. So I think she had the ability to see where their hands were at the time. And to give you, I think the best case there is probably just the Ridge case. That's 455 Mass 307. That's talking just about, it's just a case that generally talks about how the prosecutor is able to draw inferences that are reasonable, and they don't have to be necessarily inescapable, but they just have to be reasonable. So I think that's probably the best case on our side, because these issues are so fact specific. So I don't have a case that's specifically on point, but if you look at the testimony here, I think it was a reasonable inference. And even if it wasn't, regardless, as I was saying previously, I don't believe this rose to the level of substantial risk. And if there are no other questions on this point, I'm happy to move on to the next. So to the next issue.
Well, before we go there, didn't the victim testify herself that she didn't believe it was an accident?
She testified that she told a teacher right after this happened that it was an accident, but that even at that point, she said, I didn't believe it was an accident. I was at the time trying to protect him, but I knew it wasn't an accident. Yes, so the victim testified that this wasn't an accident, that both incidents, both inside the school and outside, were intentional.
Speaking of whether there's one or two incidents, I noticed that in the closing, the prosecutor says that there are two incidents on the 13th. In your view, on appeal, are we looking at this as one incident or two?
I do submit that it's a little confusing. And I want to point the court's attention to the first volume of the transcript on page 6. Before the evidentiary part of the trial began, the prosecutor did say the March 13th incident is essentially a prolonged interaction through two different areas of the school. So at the time of trial, the prosecutor was presenting this as one continuous incident of assault and battery. On review, in my review of this is why I looked that up, because I was confused. In my view, I think either of those two instances would have been sufficient for assault and battery.
But would we then need a specific unanimity instruction if we view it as two separate incidents?
Yeah, so it obviously would have needed to be handled different down below, but if you're looking at, I guess on the prior issue as a substantial risk issue, I think it goes to that. But the prosecutor really presented this as one continuous instance of an assault and battery.
Well, if it's one continuous incident, is what happened in the hallway sufficient to support the conviction?
I believe it is. Yes, I believe it is. The victim testified it was an intentional act. You see the result, her head going back and the glasses falling off. I believe it is.
And is that on the video, her head going back and the glasses falling off?
Yes. Yes, the actual impact is obstructed, but the head going back and the glasses falling off is on the video. And I believe both the victim and the juvenile testified to that as well.
Forgive me, did you give us the video?
I did not, Your Honor. So on the issue of the allegation that the prosecutor improperly vouched for the teacher's testimony, I would like to draw a distinction from some of the other cases where there was clear vouching. You know, there was one case where the prosecutor said, "This is the most laid back police officer I've ever seen testify." Things like that are clearly an expression of a personal opinion of a prosecutor, or really bringing the power of the office behind the prosecutor. Those, this court and the Supreme Judicial Court have clearly recognized as improper. Here, I don't think she really crossed that line. She was really asking the jury to say, you know, use your powers of observation, look at how she testified, and think about maybe why she was testifying, why all these parties were testifying. And in fact, the juvenile asked the jury to do that as well. You know, think about why the victim testified as she did, and think about why the juvenile testified as he did. So for the reasons I really laid out in my brief, I don't believe she crossed the line here. If there are no further questions, I can also then move on to the jury instruction issue. You know, I recognize in my brief that this court has found that the particular way that the judge distinguished between general and specific intent has been recognized as perhaps unnecessary and confusing, but has not gone as far as to say it's an error. And I think especially in this case, where we're not dealing with a specific intent crime, and where there are no allegations that the element of intent as part of this crime was described in an erroneous way, I don't believe it made a difference, and I don't believe it was error.
So you're saying the label was wrong, but the instruction was correct?
You know, I believe it probably, in hindsight, it probably shouldn't have been provided. It's just extra information that didn't need to be there, but I think intent was defined correctly.
But it was defined as specific intent when this is not a specific intent crime, right?
Well, the jury was just kind of given a little lesson on the difference between general and specific intent when they didn't really need to understand that in order to determine.
But wasn't the instruction incorrect? The definition of specific intent was in fact the definition of general intent, was it not?
It's using intent as I think the court described it in that footnote. Is using intent is just a different definition of intent. It's not really in the legal way. It's more in I don't even know where this came from, to be quite honest, where this instruction came from and why it's still circulating around, because it's a little confusing to me, to be quite honest.
Well, in the question that was asked, that the jury asked the judge about the intent that was required in this case, did the judge correctly answer that question?
Yes, Your Honor. Yes, Your Honor. And the judge also correctly defined accident in giving the general jury charge. And that was the juvenile's main defense here. So all the elements of the crime were correctly defined when he went through the elements of the crime. The defense of accident was correctly defined, and the question was properly answered. So there is no substantial risk in this case for all of those reasons. And then as to the last issue, whether there was a specific jury instruction warranted here as to the juvenile's age, there is no case law cited saying that the trial judge sua sponte must provide such a instruction, and I don't believe one would have been proper here for all the reasons I stated. I'm happy to answer any specific questions on this. But otherwise, I will rest on my brief.
Panel, any questions? Seeing none, thank you both.
Thank you.
And we wish you a healthy and happy balance of 2021.
Thank you very much.
We are live.
Good morning, everyone. Welcome to the March 2nd sitting of the Massachusetts Appeals Court. My name is Mary Thomas Sullivan. I will be on your panel today, as well as Justice Desmond and Justice Singh. Even though we are here on a remote platform, we will follow all the usual rules of oral argument. Each side will have 15 minutes to present their case. There will be no rebuttal. You can assume that the panel is familiar with your briefs, and we urge you to get to the heart of your argument. For those of you who are watching us today, we hope we will have no technical issues. We do have one lag time issue with a difference between the voice feed and the picture feed for one of us today. We hope that nothing else goes amiss. If it does, it may be that we need to go offline for a moment to fix it, so your screen may go blank. If so, please be patient, bear with us. We will return and we will make sure that the parties each get their 15 minutes. And finally, if for any reason you see any of us looking to one side or another, please, that is no sign of disrespect or inattention. We have our other case materials and our notes to either side of our screens, and we may be referring to them for purposes of formulating our next question or understanding better the parties' arguments. So with that, I will call the next case, which is 20P0255, Commonwealth versus Clark. Attorney Romeliotis.
Thank you. I am Christula Romeliotis and I represent Elijah Clark. I just wanted to start by noting a few principles that I think are important in this case. Actually, what I wanted to start with by saying is that I'm focusing on issue 2 from the brief at this point. And a couple of principles that I wanted to make note of. One, as we know, statements in a closing argument that are reasonably susceptible of being interpreted as a comment on the defendant's failure to testify are improper. Prosecutors in closing may not comment or even infer or make a comment that infers on the defendant's silence. And prosecutors should scrupulously avoid any statement that suggests that the defendant has any burden to produce evidence. Here, I want to focus on the Commonwealth statement in closing, where the Commonwealth said that there were not two stories. There were, quote, "There was Ms. LaRoche's testimony. That's the evidence. Her testimony is the evidence." And I'd like to argue that that statement crossed over into improper closing argument, and to remember that the defendant did object to that statement. This statement was erroneous.
Can't that statement be viewed as a direct response to the defendant's opening statement, which said that you're going to hear two different stories. I'm going to say very, very different stories. Ultimately, it's up to you to get a sense of what happened and what didn't happen. At the end of the day, the decision you have to come to is guilty or not guilty, but you'll hear two different stories. So can't that closing be in direct response to what the defense promised the jury they would hear?
I think that I think that the Commonwealth obviously can respond to that statement that defense counsel made in opening, but the way this statement was made and the words that were used in this statement crossed over to an improper place. Yes, the Commonwealth can argue that, the testimony was consistent, but by saying that there weren't two stories and that Ms. LaRoche's testimony was the only evidence, to me suggests that we have crossed over into that improper testimony where the improper argument, where we're saying that, the defendant had some obligation to testify and to present that other story that wasn't available because he didn't testify.
Well, we're obligated to look at statements in closing argument in full context. So, in full context, it was a response to the defendant's argument about you'll hear different versions or you'll hear two versions of what happened. And the prosecutor specifically says, talks in terms of the consistency of the victim's testimony. She didn't, in fact, it wasn't really a comment on the defendant giving another version, but the victim giving multiple versions. And that's what the prosecutor was really speaking to. She didn't give you multiple versions. She gave you one consistent version all the way through. Isn't that, when you look at the prosecutor's argument in total, he specifically references her consistency in testimony, the fact that she didn't give multiple versions of the events.
I understand what you're saying, and I know that that is certainly one interpretation of this, but I think that the language that was used here isn't just that, the defense said in the beginning that there were going to be two different versions here. Obviously that, is a given, and that there weren't. But the statement, the two sentences next to one another are what give me concern, that there weren't two stories and that there was Ms. LaRoche's testimony. That's the evidence. Her testimony is the evidence. In addition to that statement being slightly factually inaccurate, which I don't need to, dwell on, because her testimony wasn't the only evidence. There was other evidence. There was testimony by the police chief. That statement saying that her testimony is the evidence, is the only evidence, to me drives home some idea to the jury that, wait a minute, the other story should have come from some other evidence, and the other person who could have developed that story was the defendant. Where was he? Why didn't he testify? It's a concern because the standard is pretty high. And we're not even looking at anything that is too onerous here. The standard is, statements that suggest that the defendant has a burden to produce evidence, statements that are reasonably susceptible of being interpreted as a comment on the defendant's failure to testify.
So let's say that I agree with you that it was reasonably susceptible to that interpretation. Hey, look, we only have testimony is her testimony. You don't have two versions. And the implication is defendant didn't give you his version. He didn't testify. How are we to evaluate whether this was prejudicial error under these circumstances?
How to evaluate whether, okay. And so here, my argument in that regard is that the Commonwealth's the Commonwealth's case was not overwhelmingly strong. There was Ms. LaRoche's testimony. There was testimony by the police chief who didn't indicate that she saw any of the marks or bruises that one would have, and that she would have generally expected to see from this type, the way that the holding, the slap, etc., were described with the force. She would have expected to see some sort of mark. To me, that weakens the Commonwealth's evidence. So you have slightly weaker evidence. You have a general instruction to the jury, the adverse inference instruction, which was properly done as an adverse inference instruction, but could have been stronger. The jury could have been specifically told, ignore that statement. That statement is not part of the closing. Don't listen to that statement. That has supported in case law where, the court has said the impact of an improper final argument can be mitigated by a statement that the argument is inappropriate, and a certain statement from the argument should be disregarded.
Was there a specific request? I know that there was an objection, but was there I think the judge simply said, noted. Your objection is noted. Was there anything else done to say, Judge, but you need to instruct, I asked you to do this?
I don't believe that instruction was, I'm sorry, that request was, I don't believe that request was made, no.
At the time that you did object to, or at the time that there was an objection, didn't the judge say that, it's not really a commenting on the lack of the defendant taking the stand, but that a different story could have been elicited by way of cross-examination, and that to him, the two stories doesn't require the defendant to testify. He was saying that the comment was commenting on the consistency of the government's case. Wasn't that the court's reasoning?
Yes, that was the court's reasoning, but I still argue that that statement was improper and that the judge was wrong, and that and that something more, a stronger instruction should have been given to make sure that the jury didn't hear this improperly. The standard is high for the prosecutor to not make statements like that. And again, like I said earlier, we're looking at, suggestions of an improper statement, or suggestions of a statement that the defendant didn't testify, not an outright blatant statement. A suggestion is enough. A reasonably susceptible is enough.
Was there a specific instruction on how, there's an instruction regarding the defendant not testifying?
Yeah.
Was that requested?
I'm sorry? Was
that requested and given?
Yes, that was given. That was given as part of the standard instructions.
Okay, so they had a specific instruction that the defendant has a right not to testify. You shouldn't consider that in your deliberations.
Yes, that was given. Yeah, but there are times where a stronger instruction is needed. There are times where specifically statements where the jury needs to be specifically told that this particular statement should be disregarded. Never, in addition to the more general instruction that in this situation, there are times where a closing argument, where a judge needs to instruct that a statement in a closing argument should be disregarded, to pinpoint that specific statement and to make clear to the jury that that statement needs to be disregarded.
And you felt here that the government's closing argument was so far over the line that indeed it required that type of an instruction. That's your argument?
Yes, it is.
How do we respect defense counsel's role in this circumstance? Defense counsel may have considered that it was more than was needed to ask for a forceful curative instruction because he or she didn't want to draw attention again to the defendant's decision not to testify, and may have decided to rely on the fact that the general instruction was going to be given. So how do we know when we don't have a request from defense counsel? How do we know when we're not interfering in an otherwise strategic decision?
That's a very good point, and I'm not sure right now that I know exactly how to respond to that. I would think that in this situation that it wouldn't stress the fact that the defendant didn't testify in a negative way, that giving a stronger instruction in that regard would focus that important right that the defendant has not to testify, would focus the jury on that, and that it wouldn't adversely affect the defendant's defense in this regard. Unless anybody has any further questions, I just wanted to briefly sum up by asking that the court interpret this argument in a manner that protects Mr. Clark's constitutional right to not testify or produce evidence on his behalf. I'd also like to mention that otherwise, in terms of issue 1, I will rest on my brief unless anybody has any specific questions on issue 1 or anything else on issue 2.
Panel, any questions? Hearing none, thank you very much.
Thank you.
Attorney Townsend.
Thank you. May it please the court, Thomas Townsend for the Commonwealth. I likewise will rest on issue 1 unless there's inquiry from the court and turn my attention to issue 2. Now, the defendant's argument in both his brief and in argument presented today omits the key third sentence from the prosecutor's argument. Prosecutor said that defense counsel had promised in the opening 2 different stories. The key third sentence is, she was asked on my direct what happened. She was asked repeatedly on cross what happened. It was consistent the entire time. So I think the content and context of those words combined with what was said previously shows that he was arguing that the victim's testimony was consistent throughout. Not only was he arguing that, that's the take that the judge did. When defense counsel went to sidebar to object after the argument and made the argument that it was approaching the line of impermissible argument, the judge said he was commenting that the story was consistent. I believe that's what the argument was. Defense counsel interjected, well, that's a possible spin on it. And the trial judge cut him off and said, it's not a spin. That's one of the ways you can establish an alternative version of the facts. And interestingly, if you look at page 189 of the transcript, defense counsel then said, I agree, that was the basis for my opening. So defense counsel admits that his opening, when he talked about 2 stories, it was he intended to elicit 2 stories on cross-examination. It didn't pan out that way, but that was his intent. The prosecutor in his closing pointed that out, as he was entitled to do under this court's decision in Ahern. Prosecutor is entitled to comment on when the defense attorney in opening promises certain evidence but doesn't deliver. And the comment referred, as the trial judge had interpreted it, as the prosecutor had intended it, and as defense counsel had intended it in his opening, to cross-examination. And that was proper argument to argue that the victim was consistent on direct examination, and in the very lengthy and dogged cross-examination, she stood her ground. And I believe that there was no error here for that sort of argument. Read in isolation, I admit, those 2 sentences in isolation can give pause, and they gave me pause when I read the brief. But then I read the transcript, and it became clear. All right, the context makes it crystal clear what the prosecutor was referring to, and that was the cross-examination of the victim. On top of that, there was some reference to the judge's instruction on the adverse inference that the jury may not draw from the failure of the defendant to testify as a general instruction. Yes, it's a general instruction, but it's not a powerless general instruction or an ineffective general instruction. It's not like the old closing arguments are not evidence instruction. The adverse inference instruction is a strong instruction. The judge instructed the jury, and I quote the entire instruction in my brief at pages 18 and 19, in part, you are not to draw any adverse inference against the defendant because he did not testify. You are not to consider it in any way or even discuss it in your deliberations. That is a forceful and powerful instruction. So to the extent that any juror, despite the context and content of the argument, somehow read into it as the defendant's failure to produce certain evidence, the judge instructed the jury that they may not do that, not even think about it, not even mention it in the jury room. And the jury is presumed to heed the judge's instructions, and there's no indication here that they did not. Unless there's further inquiry from the panel, I'm willing to rest on my brief on this issue as well as the first issue.
I just wanted to ask about defense counsel in this case did object to the prosecutors, to the language in the prosecutor's closing. was there an obligation on defense counsel to do more than object?
No, because this falls into the realm of tactical decisions. There's a certain school of defense attorneys that want to draw out or have the judge single out certain evidence or what occurred at trial, and there's others who'd rather just leave it alone. So to the extent that there was any error, and again, our argument is there was no error. I mean, the question presumes error here that there had to be remedy. But even if it were error, defense counsel would be within his or her rights to request an instruction or not request an instruction. And of course, there's no claim here of ineffective assistance of counsel for failing to request a more pointed instruction. I don't know what kind of instruction could be more pointed than what's here, other than specifically calling out the prosecutor's argument on that aspect, because the general instruction, the no adverse instruction, is a very powerful instruction.
Or perhaps a motion to strike that portion of the prosecutor's argument.
Right. And again, if a motion to strike had been lodged, it would have been denied. I think that's pretty clear from the record, because the judge did not interpret the prosecutor's actions as going toward the defendant's right not to testify or otherwise produce evidence. He interpreted it as going to the cross and direct examination. But again, so if he had, I think it's pretty clear, if he had asked for a motion to strike, that would have been denied. But in the ordinary context, when it is something that is offensive or objectionable, a motion to strike certainly would be in the cards for defense counsel. And whether the defense counsel chooses to do that, I think, again, that is the decision having to do with tactics and strategy, and whether defense counsel wants to draw the jury's attention further to it. This is all at sidebar, so presumably the jury cannot hear what's going on. But it's a classic tactical decision that counsel differ on as a matter of strategy.
Any further questions? Seeing none, thank you both very much, and we wish you a happy and a healthy balance of 2021.
Thank you.
We're live.
Good morning and welcome to the March 2nd sitting of the Massachusetts Appeals Court. My name is Mary Thomas Sullivan. On your panel today, there will be me, Justice Desmond, and Justice Singh. The virtual oral argument is conducted in exactly the same way as an in-person oral argument. Each side will get 15 minutes and there will be no rebuttal, and everyone is encouraged to get to the heart of their argument. You can assume that we are familiar with your briefs. We have had some minor technical issues today. One of our panel members his voice will precede his video. We hope it's not too distracting, and we hope that that is the worst that we encounter for the balance of the day. If by any chance we do encounter a more substantial technical problem, we will ensure that the parties get their full allotted time to argue. For those of you who may be watching, we may have to go offline for a moment. So if we do, have patience, we will return. And one other last note, you may see us from time to time look to one side or another. We mean no disrespect, there is no inattention. We are simply referring to our notes, to the transcripts, or to the briefs. The next case will be 19P 1303. FT number 225048 versus Sex Offender Registry Board. This is an impounded case, and the attorneys are reminded to use pseudonyms. Thank you. And with that, Attorney Elliott, you may proceed.
May it please the court. This is one of those cases that are derivative from the essential case 496501, where it is discretionary for the court to make a remand if the hearing examiner did not make a finding that internet dissemination was essential to her determination that this person was a level 2. And I would say that this is one of those cases where the court should exercise its discretion to make this remand and have a de novo hearing. Because one of the critical factors is that, as the court is well aware, the board needs to find whether there's a risk of reoffense, how dangerous the person is, and then finally whether internet dissemination is necessary or effective to protect the public. And I think that in these kinds of cases, there's a tendency to simply say, well, internet dissemination, that's just an add-on. I mean, why did the Supreme Judicial Court make such a big deal about it? Why is it so important that the hearing examiner find that that internet dissemination is necessary? And I believe that in this case, it's evident that she didn't make that finding. She didn't make that finding because she didn't have the benefit of the Supreme Judicial Court decision. And I think that the internet dissemination is really the critical part of the law. I think that's what the Supreme Judicial Court recognized. In other words, risk of reoffense is an incredibly important assessment. The dangerousness is obviously a very critical assessment, but ultimately the whole purpose of the statute is to protect the public from a dangerous person. So if that finding isn't explicitly made by an examiner, and that finding, by the way, is both in the law and in the regulations, if that finding isn't made, then the decision is flawed. And that is what happened here. And it's obviously no fault of the hearing examiner or the board, but it's simply an extra imposition by the Supreme Judicial Court saying to be in compliance with the law, you need this particular efficacy. You need to make a finding that internet dissemination is absolutely necessary. The other reason why I think a remand is justified in this case is the hearing examiner, the preliminary recommendation back in 2017 was for a level 3. After she had listened to all the evidence, she went with a level 2. That means that her mind was open to possible change. And because her mind was open to possible change on the first and second prong, her mind might also be open to possible change on the third prong. Then
would it be reasonable for the court to conclude that the public safety is better protected with internet dissemination on these facts, where it appears that any unsuspecting potential girlfriend with children, those kids are at risk with this offender?
I think that there were many protective factors that were even noted in the decision back in 2017. For one thing, he was put on probation for 5 years. I think he was released just about 2017. And that probation, it's true, would be expiring, but that would, nevertheless, I think it's still in effect until 2022. So I think he's got an additional, that might mitigate against the need for internet dissemination. His victims, according to the examiner, were all, what she found, and I think there's some dispute about this, but she found that they were all intrafamilial. It was a daughter and then sisters of the girlfriend. The examiner referred to them as aunts, but they were all very young and they seemed to all be living in the same house. And the examiner in 2017 specifically found they were intrafamilial. And the reason why that's important is because it suggests that his pool of victims is narrow, very narrow, and is grown, and the risk of recidivism is less among intrafamilial family members. So the public as a whole need not necessarily be protected, which goes back to the reason why it's very important to determine whether the public needs protection.
Well, we don't have some form of dissemination that goes to single ladies with children, do we?
No, not that I am aware of, but whether or not this individual is a threat to the public is still something that needs to be evaluated, because the risk of recidivism for intrafamilial family members, according to the literature, is much less than it is to the public. This is not somebody who went out and attacked a stranger. And I would also note that there were many mitigating circumstances that the examiner noted back in 2017. She noted that he had a strong support network, that he had participated in sex offender treatment, that originally he had been resistant to the sex offender treatment, but then he changed his mind and got good remarks for that. His criminal history, although there was an extensive criminal history, it was generally a non-violent criminal history. And I think, and he was also, it looks like he was gainfully employed most of the time, and he was certainly intending to work after his release. So I think this constellation of factors is probably what caused the examiner to already reduce him from a 3 to a 2. And which also raises the question that even further, if she had to decide whether he was actually a threat to the public, she might say, no, he's not really a threat to the public. He's not going to be, because he's got all these other protective conditions. So because I can't find that, she would then, he would then be reduced to a 1. So I think he has a really good possibility of his getting a reduced remand here. And I noticed that—
If I may, counsel, just one question. Are the 2 sisters-in-law, who are only 8, or the girlfriend sisters, are those intrafamilial victims or extrafamilial victims? Or suggest that because marriage to them would not be prohibited under General Laws Chapter 207, Section 1, that they were in fact extrafamilial victims.
I looked into that issue because it was raised by my brother at the board, and the regulations, that's one qualification for making a distinction between extrafamiliar and intrafamiliar. But there's also, in those board's own regulations, they talk about a substitute live-in relative who you might not be directly prohibited from marriage, but that person would nevertheless, by virtue of staying in the same house, become intrafamilial. And I think that that's why the examiner in 2017, when she looked at it, and she was very closest to the facts of anybody, she looked at it and she simply said in her findings, the 3 victims were all intrafamilial. And now the board seems to be changing its position and saying, well, maybe they were actually extrafamilials. And I think there's a contradiction there. I wish I had—
Well, I guess the question is that a question of fact or is that a question of law?
I guess in this particular context, it's probably a question of law, because it's the law that's defining the relations. But as I said, if you look at the actual relation, they group various subgroups in the regulations are grouped, and it's not as if he was going out and searching children from other parents, or that he was going and attacking any stranger. These were all people that were known to him, that were living in the same household. I guess those are the points I would make.
So with respect to your second issue, Are those issues properly before us, given the factual circumstance of your client?
Which issues would those be?
Talking about the jurisdiction.
Oh, with regard to the jurisdiction, I think that it's an interesting issue. It's an interesting issue, but essentially, he had the intention to move to Rhode Island. I do not think that the point is necessarily moot in 2017, and I don't think it's really, I think that's when the decision needs to be made. He had the intention to move to Rhode Island. He was not going to be a Massachusetts resident. And one of the things to look at is on the very first page of the examiner's decision, it actually says intended address, such and such a street in somewhere in Rhode Island. It actually says, gives the particular town. So the board was well aware that he was actually going to move out of Massachusetts. And residency is intention is very important to residency. In other words, the board actually, not even the board, but the actual enabling statute says, if an examiner, if a petitioner is planning to move to another state, then the state of Massachusetts will notify that particular jurisdiction that the person is coming. And by citing the law, the board actually admits that if he had moved at that point to Rhode Island, he would have actually, the board would no longer have had jurisdiction. The statute says anyone who's intending to move in 10 days is essentially no longer a resident of Massachusetts. Now, his problem was that he was in prison when he expressed that intention. In other words, but why should his incarceration status interfere with the fact that he had an intention within 10 days of his release to move to Rhode Island? So I think that the question of jurisdiction is maybe a little closer than it might first appear. And because Massachusetts would have lost jurisdiction of him and he would have moved to Rhode Island. So I wanted
But he never did move to Rhode Island.
No, he didn't. He obviously.
And we know that people's intentions can change day to day, and what he relied on, which was some very general internet searches, and I think maybe a statement arguably from his mom, it seems speculative at best.
There was, once again, I would refer the court back to the actual decision itself, in that the hearing examiner put the address on the cover of her decision, and she recorded within her own decision many of the papers and records that had been submitted. I would, before I conclude, I would just like to, and I may send a 16L letter on this, I would like to draw the court's attention to a couple of unpublished decisions. The 62-427 on October 28th, 2020, 19P 850. That was an unpublished decision with the same issue that resulted in a remand. And also Doe 35-6197, just decided in December 30th. That's 19P 715. Two decisions from the appellate court, of which I think one of the justices may be very familiar, that resulted in a remand to the board for this a critically important question of whether internet dissemination is useful. And a lot of time has passed, and in a de novo hearing, if his behavior has been good, that might result in a lower classification. And if there are no further questions, I would rest on the brief.
Panel? Being done, thank you very much. Attorney Shania.
Good morning, Your Honors. I'm just waiting for the clock. Oh, there's the clock. If it pleases the court, David Shania for the board. I'd first point out that the issue as to internet dissemination is really in your hands today, because 496501 and 23656 give you the authority based on the evidence to make the determination of whether or not internet publication would serve a public safety interest in this manner. And I think you got to follow the 3 steps that 23656 have, which is first, whether the hearing examiner's decision that this individual's level 2 was supported by substantial evidence, which, because no record was produced for this case, that point has been conceded. The second is whether or not this individual's dangerousness and the factors indicating dangerousness rises to that level 2. And I would submit in this case it does. You have an individual who clearly, based on the application of factor 3 being prepubescent children, has at least an indication of a deviant interest in children. And then you look to whether or not the severity of harm he would cause should he reoffend. And what you're looking at is an individual who could reoffend against prepubescent children. That would include penile penetration of the children. It could be multiple children. All of these issues are wrapped up into whether or not this individual's publication of his information would serve a public safety interest. I think you also have to look at the fact that at the time of the hearing, he had been in prison for 11 years, 9 years. So he hadn't been out in the public. And I think you have to take that into account, according to DOE 496501, that an individual who has not been in the community because they've been incarcerated, the court really needs to look at their prior sex offending behavior to determine what danger they actually will pose and what harm they could cause should they reoffend. So I think the record is clear that in this case, internet publication of this individual's information does serve a public safety interest. The fact
Counsel, I noticed that you didn't mention the familial relationship, and I'm looking at factor 7 here. Would you agree that these are sisters-in-law and therefore an intrafamilial victims?
I wouldn't agree with that because the factor 7 is based specifically on the Massachusetts definition of kinship through marriage. And the sister-in-laws don't fit within that. Now, there's one sister-in-law that indicates that they may have been living together. The first sister-in-law, the older one, said when she was 8 is when the individual started dating her sister. So again, I think the hearing examiner erred by making this an intrafamilial relationship with the sister, at least one of the sisters-in-law.
Where the parties were married. The Doe was married to the woman, correct?
My understanding was that for the first one, he was dating the woman. The first sister was sexually abused while the woman was being dated by the defendant or by the plaintiff. So in that sense, again, I think the hearing examiner erred in making this intrafamilial to the benefit of the plaintiff in this case in the analysis. But I think on a remand, it may be found a different circumstance, especially with the older sister who again said.
If I may, counsel, just before you go on, I'm looking at, darn, I just lost it. Factor 7, section C specifically says adoptive children, first cousins, brothers, and sisters-in-law are intrafamilial members. So at least as to the other sister, I mean, I don't know what happens. I don't know if we look at this retrospectively, but 1C, if I'm looking at the version at the back of your brief, specifically references sisters-in-law.
Right. And my focus is on the first sister who said it occurred when they were dating. And I think that's important because even if they were living together, it has to show that if they were living together less than 2 years prior to his sexually assaulting the girl, she's not considered intrafamilial. And her and my understanding of the evidence is that she said that they had started dating at the time that she was sexually abused by him. So I don't think she would fall under intrafamilial. And more importantly, if she doesn't, the factor says anyone who has targeted an extrafamilial victim. So it only has to be one of the three to be extrafamilial. So
you're saying there's one intrafamilial and one extrafamilial.
In the sister-in-laws, I think one of them can be considered intrafamilial, and the first one claims that it happened while they were dating. I think she's extrafamilial, and I think that changes the dynamic here. I think any woman that this individual may date, her sisters, if they're prepubescent, or her own children, or children that they may have, may be at risk with this individual, and women should know his background before they become involved with him. And that's pretty much the board's position on the internet dissemination. I think this court has the authority to make that determination. I think the evidence in this case supports it. And again, I agree, there are some cases that we've remanded for this issue, some that I've agreed with the remands, but I think this one's pretty clear cut because of this sexual deviancy, the amount of the individuals involved, and the fact that this individual is just released from prison and could begin dating. And I think women should know about his background, especially if they have connections to small children. And as for the residency issue, I think my brief covers it very clearly. I think that this is not a case that should be remanded because of the jurisdiction issue. He never left Massachusetts. And I think that is pretty much the bottom line on that issue. We still have jurisdiction over him. And I think if there's no further questions, I could rest on my brief.
Panel? All right. There being no further questions, we thank you both and wish you both a health and Justice Singh. Our oral argument here, though virtual, will follow all the normal rules of oral argument. Each side will have 15 minutes to present its case. There will be no rebuttal, and you are each encouraged to go to the heart of your argument. You may assume that we are familiar with your briefs and with substantial portions of the record. To those of you who are watching, we hope that there will be no technical issues. In the event that there are, we will do our best to correct them. From time to time, this has required going offline. And so if your screen goes blank to the feed, please don't worry, we will return. And finally, if you should happen to see any of us look to one side or another, this is not a sign of inattention. We don't intend any disrespect. Our notes and our copies of the briefs and the transcripts are to one side of the screen or the other, and we are merely referring to them in order to formulate our next question or better understand the argument. The next case is 20P0706, David versus Kelly. And Attorney Hefner, you may proceed.
Good morning, Your Honor, members of the panel. May it please the court, Peter Hefner, representing the defendants Jonathan and Donna Kelly. The court has asked us to come prepared to discuss the case of Antoniadis versus Bass Knight, and I'd like to start right there if I may. The question in Antoniadis was whether the court erred in allowing references to the plaintiff's insurance and the subrogation nature of the claim throughout the conduct of the trial. And the appeals court concluded that where the judge's decision was not based on a valid evidentiary need, but was instead based on a legally irrelevant concern, the court concluded that the judge made a clear error of judgment in weighing the factors such that the decision was outside the range of reasonable alternatives or a inappropriate exercise of discretion. And the defendant submits that is exactly the case here, and that a new trial should be awarded on that basis. The evidence of the amount of workers' compensation payments or the amount of medical bills paid under workers' compensation is legally irrelevant under the long-standing collateral source rule. And the Antoniadis decision, as well as other decisions, the Goldstein versus Gontaras decision, have previously expressed the legal irrelevance of that information in the context of a tort case. The Goldstein versus Gontaras case, the court went a little further.
Before you go any further, counsel, I'd just like to ask you two foundational questions so that I can listen to your argument in the proper context. The first is, this is both a direct appeal and appeal from a denial of a motion for judgment notwithstanding the verdict. What do you think our standard of review is?
I believe it's abuse of discretion on the issue as to whether the evidence was appropriately admitted. I've not focused as much on the denial of the motion for a new trial. I've really focused on whether the evidence should have been admitted in the first instance.
Okay, and then second, I appreciate the reference to the collateral source rule, but that is usually an argument that the plaintiff is making to keep evidence of insurance out. We have here a bit of the converse. Does this case also implicate the rule invoked more frequently by defendants that evidence of insurance is inadmissible?
It does and it doesn't. And I think all of this is wrapped up in the Mass Guide to Evidence, section 408, and as well as the Maria versus Costco case, where the court ruled in Maria and it switched its position from the prior position that had been in Massachusetts for decades, that evidence of another settlement is not admissible in a tort case.
I understand you've made that argument, counsel, but that argument was not made in the trial court, was it?
I think it's all consumed in the whole notion of what the collateral source rule is.
Was the argument made that this was evidence of a settlement in the trial court?
Not in those words, no.
No, okay, because arguably if it's not, it's waived. I didn't ask the question in order to have you go down that path. Let's just say that. You may wish to return to it, but your primary arguments in the trial court were based on the admissibility of insurance.
Well, no, it was the collateral source rule in general, and that the collateral source rule is not a rule that the plaintiff owns that can be waived whenever the plaintiff deems it appropriate, but it incorporates a number of different principles. And I think that relevance, prejudicial impact of evidence, it's all incorporated in all of the cases that address the collateral source rule. And here, the main concern, obviously, was a governmental determination or adjudication that nobody was going to hear about, that all of the medical expenses were somehow related to the accident. And so there was two arguments on this point, and the judge got it. The judge understood exactly what the situation was. The first basis to proffer this evidence was to avoid an inference of double recovery. And the court appropriately went right to an instruction that she said that she would give and that she gives frequently, and that is that you are not to consider other sources of recovery, and the court can take care of any issues with double recovery. And that's what happens in many cases. And then the case went further with this notion of malingering.
Can I interrupt you for a moment so I'm clear? Is it your position that it was okay to bring in the fact that the insurance was involved, but you quarrel with informing the jury as to what the specific number was?
That's the main focus, Your Honor. I think the better practice is you don't talk about it in the evidence. The judge may say in an instruction that you are not to concern yourself with collateral matters such as workers' compensation insurance or other insurance. And that's typically how it's handled. But our main focus here was that telling the jury the amount that was paid and that he was paid for 2 years out was telling the jury that the government had made a determination on causation. And that's exactly what the battle was here in this case.
So I understood your brief to be arguing exactly that. Not that we argue that the insurance was brought in, but we argue that the specific number was the error.
Yes, you're right. I think, again, the evidence is not going to talk about workers' compensation or lack of workers' compensation, and it shouldn't. The evidence, but the instruction generally takes care of the double recovery inference that the plaintiff feared based upon common knowledge as to the existence of workers' compensation coverage. So
So my understanding is that you're objecting both to the fact that evidence came in that they're of workers' compensation, even if no amount had come in, and to the amount.
Yes, it shouldn't have come in, and the amount should not have come in evidence. An instruction at the end: do not concern yourself about collateral matters, such as often given. There's no concern there. The concern is any discussion about this in the evidence, because the collateral source rule and the relevancy standards clearly, in our view, say that this is not something that should be discussed in the evidence, and therefore shouldn't be brought up in the opening statements. And that's what the motion was about, was looking for permission to bring it up in the opening statement and then bring it up again in the testimony. And again, the suggestion that malingering was somehow at issue here, I suggest to you there's a significant difference between the plaintiff having to prove causation and an argument that the plaintiff is malingering. And in this case, I think it's important to keep in mind that both experts were testifying by way of audio-visual depositions that had been secured beforehand. So the defendant's expert never said anything about malingering. The defendant's expert basically testified that without swelling right after the accident and without the findings on MRI, and in the context of a person who after, I think, the second visit, he said he didn't have any pain, that whatever they found in that surgery was not caused by the dog bite. And that's the issue here. We have both experts acknowledged that you can have a traumatic tear of the TFCC or a degenerative tear of the TFCC. Traumatic tears happen when you fall on an outstretched hand, or they give the example of a drill being applied and the bit being caught in a violent twisting. Degenerative tears just happen. So the defendant's expert—
Those were general ways. They weren't the only ways that these injuries can occur, but they were what typically occurred in that fashion. That was the expert testimony. Is that fair to say?
I think both experts testified to those points and that they happened degeneratively as well. I don't think other examples were given.
And this plaintiff was 26 years old, right?
Yes, he was, yes.
And is there a distinction in your mind between fabricating an injury and malingering, which to me suggests you're making the injury last longer, you're staying out for longer. We're not disputing there was an original injury.
I think fabricating in the context of staying out longer is the essential equivalent of malingering, but the defense never suggested that that was going on. The defense expert never said this surgery was unnecessary. The defense expert never said that he stayed out longer than he should have. What he said was that this was, my opinion, it was not caused by the dog bite that left nothing but a superficial abrasion, had no findings on the testing immediately after the accident, and where the plaintiff was saying he was pain-free after 3 days. And that was the defense argument as well. The defense argued at the end that the jury did not have to accept the plaintiff's statement that he had this tug-of-war type of situation where he violently flailed. And I'll point out to you that the supplemental record appendix has chronologically all of the medical records that were submitted to this jury after the first item in the supplemental record appendix is a report from the plaintiff expert, Dr. Tello, I believe, and then it's the treatment records. You don't see that history anywhere in the treatment records of this tug-of-war of violent flailing. So on one hand, you've got a plaintiff expert accepting a factual situation as suggested by the plaintiff in his deposition testimony and his trial testimony. On the other hand, you have a defense expert who is accepting what's in the medical records and saying on these medical records, it's not related to the dog bite. He may have something, but it's not related to the dog bite.
But I mean, not untypical in a med mal case. I mean, doesn't that go to the weight of the evidence?
Well, I think that's the fact, is you don't want to throw your thumb on the scale of the weight of the evidence. And when you throw onto the scale that the government has determined that all of these medical expenses that have been submitted to the jury were paid under the workers' compensation system, now you have really thrown your thumb on the scale. And I don't think, I respectfully submit, it could not be fixed. And
let us say hypothetically, if we were to agree with you, you still have another step, right? Which is that you have to show that the improperly admitted evidence prejudiced you in a material, your client rather, in a material respect. And the judge gave a very direct instruction to the jury that they were not to consider the evidence of workers' compensation to be in any way indicative as to the issue of causation. I can't quote it for you right here, but she said you can't consider that on causation. Why does that not ameliorate any prejudice? Why? We do have cases that say when this evidence is admitted, even improperly, in the insurance context, that a proper instruction will ameliorate the prejudice.
We do. And we also have cases that that's not in every instance. So the Fife decision speaks to the notion that the rubric that curative instructions and instructions are followed by the jury isn't always true to relieve the prejudice.
Right, but Fife is an attorney misconduct case, which was really egregious. This is not a misconduct case. This is a case where somebody won on a motion in limine and did what they were allowed to do. So this isn't that someone misbehaved. There was also a lot of in Fife about referring to facts not in evidence. If we go back to the other cases other than Fife, what would you consider your best case to be?
Wallstrom versus JPA, which is not cited in my brief. It's 95 Mass App Court 445.
That's another misconduct case, though.
Okay, but citing DeHusseis versus Yogel 404 Mass 44, the aggrieved party's burden is not to demonstrate that the trier of fact would have come to a different result. And in Wallstrom, the court said, if there's been an error, we will reverse where and where appropriate, order a new trial, unless we can say with substantial confidence that the error would not have made a material difference. And here, I don't think that can be said. When it goes to the heart of the issue, and when you have that type of evidence, even if you say disregard it, in Dunn, a federal case cited in my brief, the court said it's better to not make the error than to try to fix it afterwards. And I don't think there's any substantial confidence that that was not considered in the jury room, despite the instruction. And I see my time has expired. If there's any, I would like to just address the suggestion of the high-low agreement barring this, if I may.
2 minutes, and we'll give Attorney LeBlanc another 2 minutes.
I hope to be briefer than that. The high-low addressed two things: the maximum recovery and the minimum recovery. And that's all, nothing else. You have in this record an affidavit from one lawyer who negotiated that high-low, and you don't have any countervailing affidavit saying what he said is wrong. And that high-low agreement just dealt with the high and the low. And I'll ask that you consider a question of what would happen if there was a mistrial. Does that high-low mean that he only gets the low? It wasn't discussed. It wasn't reported to the court. It wasn't something that the court could explore. If there was a mistrial because the jurors were fighting between $500,000 and $1 million, the defendants would love to pay $150,000 low because there wasn't a verdict in excess of the 150 that was stated in there. But that's not what the agreement was. And the agreement here did not go any further than setting out a high, setting out a low, and it had nothing to do with post-trial relief. Thank you.
Thank you. Are there any further questions from the panel?
The agreement said if the number comes in here, we'll pay, right?
If the agreement said that if the number comes in for anything less than 150, then 150 will be paid, and then it had different ladders. But again, it doesn't say anything about mistrials.
I understand, but what it does say is if it comes in this number, we'll pay.
It does. It does, but that's, again, what you have is a hastily prepared memorandum that is setting forth what the two parties discussed. It doesn't change the discussion or the agreement. And I'll also point out that in Chamberlain, a case that was cited in the briefs, where it's not even signed by the parties, it can't take away the rights of the parties.
All right. Are there any further questions from the panel? All right. Thank you, Attorney Hepner, and sorry if I cut you off there. I think you were just going to say thank you.
Thank you. Not at all.
Okay. Attorney LeBlanc.
Thank you and good morning, Your Honors. May it please the court. My name is Mary Ann LeBlanc and I represent Michael David. So this was an assessment of damages in a dog bite case with a high-low agreement in place. Liability and harm were stipulated. There was a contested piece of evidence, which was dealt with in the most judicious way with curative instructions requested by the defendant and given without objection. This case should have been over and done with in 2019, and this appeal constitutes a frivolity at best. But
Is it your position that because there was a curative instruction, then that kind of takes the air out of the sail for the defendants because they requested a curative instruction?
Yes, Your Honor. What happened was,
how can that be fair? I mean, they lost their primary argument, and so now they're trying to mitigate. And to suggest that because they asked for a curative, should they have said nothing? Should they have not asked for any instruction?
Well, the judge had already indicated that she was going to give an instruction before one was requested. And a curative instruction was requested by the defendants. It was given without any objection. So the judge was left not knowing that the defendant still had any issue with this. So yes, it is curative. Yes, Your Honor. I'm sorry, I can't hear you,
Justice
Your
Sullivan,
Honor.
I think you're on mute. You're on mute, Justice.
I know, by accident. Are you familiar with the cases of Commonwealth versus Grady and Commonwealth versus Amelie, which hold that if there's a motion in limine, which you lose, your objection is preserved and that you need not object again at trial?
I am familiar with those cases, Your Honor.
They weren't cited in your brief, and they would suggest that the defendant's claims are preserved.
I think, that in this case, the instruction that was given was curative. It did properly state the law. And it is our position that the issue was waived. I think the more important issue, Your Honor, is
how can their position be waived after Grady and Amelie?
I think that the instruction they asked for was given, Your Honor, and there was no further discussion on that. For the purpose of this discussion, I'm willing to waive.
I don't think that answers my question, though. You're saying for purposes of discussion, you're willing to?
For the purposes of this discussion, Your Honor, I think I'd be willing to waive that argument. I think what's more important is that what the judge did here was not error, and the defendants cannot show prejudice. I think that's really
what was the legal relevance of that information to this particular case? What was the relevance?
The relevance of the collateral source evidence, Your Honor, was onto the issue of malingering. that was raised by the defendants. The defendants in this case opened the door to that evidence. This
Okay, so
whole
let's say we accept that there was malingering evidence, or that was the theory. How do the payments or the fact of workers' comp, how does that counter the malingering theory in this particular case?
Mm-hmm. Well, you have to first get to the context, Your Honor, which is that you have a case where the defendants are putting forth that this person, the plaintiff, is malingering, pretending or exaggerating his injuries. Number one, they're going to know as a federal employee that he received workers' compensation benefits. Whether it was put in or not, they're going to know that.
How are they going to know that? How are they going to know that?
It's general knowledge, Your Honor. And the judge in this case acknowledged that. It's been acknowledged in some of the cases that I've cited, even Goldstein from the SJC. It's common within the common purview of citizens, as the trial judge said, that they know about workers' compensation benefits,
but
particularly.
If you're right about that, then you would also be right about the fact that workers' compensation requires the proof of a causal relationship, which is the very prejudice that Attorney Hepner is complaining about.
Understood, Your Honor. I'm sorry.
So how do you then not run afoul of the other cases under Section 411 of the guide that say we don't admit evidence of insurance, particularly in a case like this where causation is the issue in this limited hearing?
Right. So, Your Honor, first of all, the jury was specifically instructed, as you noted, that they were not to make any such inference. And
that goes to prejudice. I'm talking, let's stick with admissibility for a moment.
Sure. So the evidence of compensation benefits, which, by the way, have been admitted many times before in our jurisprudence at the request of defendants, the exact amounts of benefits paid, they have come in to prove that the plaintiff was malingering. This was a case where the plaintiff was asking to put in that evidence to rebut the defense that he was malingering, okay? And it was very clear that there was never any mention, as Your Honor mentioned, of there being a settlement with the government or any governmental determination of causation. It was simply that benefits were paid relative to Mr. David being out of work after this event, and that medical expenses were paid relative to treatment for his wrist. Now, as you've also heard, there was evidence that people can have the exact kind of injury that Mr. David had naturally with degeneration. We heard evidence that Mr. David had, for 2 years before this event, had his job at the post office where he was repetitively using his hands. We also heard evidence that there was no evidence of pathology in his wrist seen for many months after this event. So the jury was equally available to believe that these injuries, while may have been related to his employment, were not related to the dog bite. It was very clear that the plaintiff had the burden of proving causation, and the plaintiff put into evidence an abundance of medical evidence. Dr. Scoff, their expert testimony, the expert, go ahead,
so
Your Honor.
If causation is the issue, would you agree that having elective surgery on your wrist is a long way to go for malingering?
I would agree with that, Your Honor.
And so the issue then becomes, is it degenerative or was it caused by the dog bite? That's the issue. The causation is the issue. And that's what your brother seems to focus on. You agree there?
I agree that that is his focus, Your Honor, but those benefits, there was no evidence whatsoever in this case, or any mention whatsoever, that there was any causation rendered by the government with respect to those benefits. Again, the jury believed that those benefits were paid for an injury suffered on the job, having nothing to do with the dog bite in this case.
Well, if that
how would that have been relevant?
Yeah, it wouldn't be relevant.
Well, the issue is that the government, the jury was going to know, I take that position and the judge backed that up, going to know that comp benefits were paid here.
No. They
So-
were going to know that they're available, right?
Maybe
It's in the general knowledge that benefits are available. People can get workers' compensation benefits. They were not going to know what specifically happened in this case unless they were told.
I would disagree with you to this extent, Your Honor. I believe they would know that benefits were paid. They would have a very strong suspicion about that, but they wouldn't know what was paid or how much. And so that, keeping all of that shrouded in mystery, which is what the defendants wanted to do, would feed right into the narrative here, which was that this was an injury to Mr. David that did not happen the way he said it did and did not occur to the extent he said it did, which robs Mr. David of a fair trial, as the judge said, without putting.
You're walking right up to the precipice of saying that the reason why you wanted to put this evidence in was to have the imprimatur of the government on the causation issue.
No, Your Honor, that was not the intent whatsoever. To establish causation, I had my medical evidence. The issue was to get Mr. David a clean slate, for him to have a fair shake, so the jury would know what it is that they want to know, which is the truth. And so the judge put in the truth in this case in an attempt to, what she said was to minimize the prejudice to all parties here, so that the jury would not make improper speculation or adjustments with respect to their verdict.
This all hinges on the malingering piece of this. Perhaps you could tell us, A, what you knew at the time, or what everyone knew at the time that you made this motion and when the judge ruled, A, because there's two time frames I think we need to look at. And B, then what occurred at trial. Attorney Hefner is saying there was no evidence of malingering at trial, but you have been adamant that malingering was a defense that you saw coming. So at the time that the motion was made and ruled upon, what is your basis for saying there was a malingering defense?
Right. Well, unlike Mr. Hefner, I litigated this case and I tried this case, and what I knew at the time.
We don't need to go there. Just tell me what.
What I knew, Your Honor, at the time of the final pretrial conferences was that Mrs. Kelly was being called to testify in this case, in a case with stipulated liability. And she was being called to testify for two reasons. Number one, to testify that she neither saw nor heard any mention of an injury to Mr. David's wrist immediately after the attack. And number two, so that she could testify, as she did in her deposition, that after this attack, Mr. David said, "Yes, I am going home." And for the record, I have recited that testimony and punctuated it with a fist pump, which is a celebratory gesture, which the defendants tried to press to get into evidence. And the obvious implication of that testimony was that Mr. David had not really suffered an injury to his wrist and that he considered this attack to be some sort of an opportunity.
And would you say that the prospect of that type of evidence coming in was a material basis for the judge's ruling?
Well, there was other evidence as well, Your Honor, including the audio-visual testimony of Dr. Kimball, which was already preserved at the time of the pretrial conferences. And that testimony was to the effect that the only injuries that Mr. David had suffered to his wrist were a, quote, superficial abrasion and a contusion. So that is all evidence that I knew was going to be coming in at the time of the pre-trial conference when the motion was brought.
So now we're down to two. You actually have 3 minutes left. I just want to ask the I'm going home with the fist bump evidence. Did that come in at trial or not?
The fist pump did not come in, Your Honor.
And the I'm going home now did not, correct?
No, she did say that he said, "I'm going home." Yes.
Okay.
Yes, Your Honor. So I would say to you that it was very clear that this was going to be the defense. And in fact, it was all summed up in the defense counsel's closing argument when defense counsel said to the jury that the Kellys should not be found responsible for Mr. David's injuries to his wrist, quote, if in fact it, meaning Mr. David's wrist, was injured at all. After all of this evidence, they were suggesting that he didn't even have an injury to his wrist. So the Kellys' defense was deliberately designed to lead the jury to believe that Mr. David had received workers' compensation benefits, which again, I submit they were going to know about in a dishonest or manipulative way. Your Honors, I do want to just talk about the high-low agreement for a moment. Am I correct, Your Honor, that I'll have an additional 2 minutes tacked on here?
A minute. Your brother only took another minute.
Okay, thank you. I do want to say that with respect to the high-low agreement, that it provided for more than what Mr. Hefner said. There's a provision where if there was a verdict of $150,000, there would be no interest paid on that.
Is that in the record?
It's in the agreement, Your Honor.
Okay.
It's in the agreement, which is page 52 of the record appendix, that if the verdict was in the amount of $150,000 or less, but with statutory interest exceeded $150,000, Mr. David would only be paid $150,000. Okay. That was also part of this bargained for exchange. This is a matter of first impression with this court, although it was addressed by Justice Peter Agnes in the Wright versus Kelleher case when he sat on the Superior Court, and he found that a high-low agreement does constitute a settlement. This issue was raised below, and the court can and should affirm this judgment on the basis of that high-low agreement. As I have said, there was no error with respect to the admission of this evidence. It was properly admitted as to malingering, much as it has been admitted on the issue of malingering for decades in Massachusetts. And in accordance with the procedure outlined in Goldstein. There was no prejudice as a result of this evidence, and I submit that the judgment should be affirmed. Thank you very much.
Are there any further questions from the panel? Seeing none, we thank you both for excellent arguments.
We are live.
Good morning, everyone, and welcome to the March 2nd sitting of the Massachusetts Appeals Court. My name is Mary Sullivan, and your panel today will consist of me, Justice Kenneth Desmond, and Justice Sabita Singh. We will follow today all the usual rules of oral argument that would be followed were we in our normal courtroom live. That is, each side will have 15 minutes to present, and there will be no rebuttal. For those of you who may be watching, today's argument is a little unusual in that the time has been split amongst multiple attorneys who are in some ways challenging the judgment of the trial court and in other ways seeking to uphold it. So we will have a lot of smaller, shorter arguments. We hope that there will be no technical issues. If there are, we will pause and make sure that they are corrected so that everybody gets their full opportunity to argue. For those of you who may be watching online, if such a repair requires going offline, we may disappear from your screen for a while, but be patient. We hope you will be patient with us as we will be patient with all of you to get any technical difficulties fixed. And finally, if you happen to see me or any of the judges look away from a direct face to the screen, we are not being inattentive and we mean no disrespect. We are simply looking at our notes or portions of the transcript or the brief so that we may better attend to your argument. The final case today is Department of Children and Families and others versus various parties. I would remind everyone that this case is impounded and that we should be using pseudonyms in all respects. I believe that the first argument will be Attorney Naring for 6.5 minutes. The timer will show 7 minutes, but counsel will stop at 6.5. Thank you.
May it please the court, my name is Ilse Neering and I represent the mother. Here there was evidence that this mother was fit to raise a smaller subset of her 7 children. In particular, there was evidence that the mother was fit to care for one child. And I say that because between January and April of 2017, for 4 months, this mother was alone with the eldest girl who had ADHD and impulse control issues. And the girl's behavior improved in school. The school said that, and the mother used the home health behavioral supports and the therapeutic mentor. And there was evidence that this mother was able and fit to raise a subset of 3, because in April of 2017, the 2 littlest ones were returned to the house. And so from April through the end of November, for a period of 7 months, the mother had 3 children in the house. And the daycare providers said the littlest ones appeared happy and well cared for. And the mother continued to use the supports in the house. She took the girl for her ADHD medicine evaluation. The girl passed her academic school year. She went to the summer sibling camp. And the mother did activities with the girl that summer. And life went on, and it was uneventful through the fall of 2000 and through November of 2017, because there were no complaints about the care of these 3 children. But everything changed on November 27th, 2017, when the 2 school-age children, the grammar school boys, were returned to the home. And then the mother had 5. And the behavioral problems with this eldest girl started immediately. In January of 2018, the school reported that the girl was backsliding into her bad behavior, and more children came. On the weekends, there were the 2 twins were coming, looking towards reunification and spending the weekend. So on the weekends, the mother had 7. And the girl with ADHD, the behavior escalated, and in May and June of 2018, there were 51 A's, and she said she didn't have the medicine, but DCF ascertained that she did have the medicine. And life goes on, but in the summer of 2018, in July, the father in Florida sends a 15-year-old girl to stay with the mother. Now she's got 6 in the house on a daily basis. And the things start getting worse. She doesn't send the children to Reading. She doesn't get them to Reading to go to the sibling camp, but she did send them to a day camp in Boston that summer. And nobody could reach her on the phone. And then it starts in the fall of 2018. There is a report in September, and that the girl is very unhappy that the cat is missing, and nobody can reach the mother on the phone for several hours, and DCF can't get in touch with her. And then in October, there's another 51A report, and the mother did have to fill the medication at that point, but
Counsel, I'm sorry to interrupt you, but your time is running down. I did want to ask you a few things. So you're seeking to have this remanded for the judge to consider what specific issue?
I think that there really needs to be a child-specific determination of the mother's unfitness to parent each of these children, because there was evidence that this mother was fit to care for the one child, the eldest girl, alone in that 4-month period. She was able to advance that child's interest, and she was fit. There was evidence that she was able to take care of that girl and the 2 littlest ones when there were 3 in the house for a period of 7 months.
But what if, I guess I'm just trying to figure out how a trial judge is to make this kind of a determination. A trial judge could make a determination that she's that she's capable of parenting each of the children, just not all at the same time. And how is a trial judge supposed to pick and choose which children and how many children? I mean, it was just happenstance of which children get returned to her at what time. What if the twins had been the first ones that came, and she's capable of handling the twins, and then the oldest girl comes later? So we say she's not capable, you know, she doesn't get the older girls, but she gets the twins. Now, how is the judge supposed to make this determination that you're asking her to make, or asking them to make?
I think that there's an analysis where you have to determine what is she able to care for this child? What does she demonstrate? And has she been able to advance their interest? And it goes down the list. And then unfortunately, perhaps decisions have to be made.
But you're not simply asking for an individualized determination, which is what we all expect to happen with respect to each child. But you're asking for a determination of how many children can this mother handle. Is that right?
Well, of course, my client would like all 7 of her children returned, and if everyone is treated individually and it's a real analysis.
Can I just ask you about how is the judge to take into consideration ultimately the mother's, you know, lack of participation at trial?
I do know that legally she can have an inference against that, and this particular judge didn't write in her findings that she held that inference against the mother.
Is the argument that you're making today that she should have been allowed to keep a subset of 3 an argument that was made to the trial judge?
I don't believe it was made to the trial judge, Your Honor.
One of the issues was the lack of communication, or the ability to communicate with mother. Is that a factor of poverty that she wasn't able to maintain the telephone, or parental unfitness?
It is my position as appellate counsel that indeed it was a financial issue, and nobody wants to be without a phone and not be available to a school for their children, and nobody wants to be without electricity and it's just the financial situation of this woman was like $200 in cash a month. It was extraordinary.
Any further questions from the panel? All right, Attorney Sollins.
Good afternoon. May it please the court. My name is Amy Sollins and I represent the oldest child. I'll refer to her by her first initial, J. Jay is in a different situation than the other children. Significantly, Jay is 13 years old and her consent to adoption is statutorily required. Jay is not in a pre-adoptive home. She is the only child placed without a sibling, and Jay is not agreeable to the department's plan of adoption by recruitment. The department's plan of adoption by recruitment is not viable because it would render Jay a legal orphan. This case should be remanded to determine whether the termination of mother's parental rights and the lower court's refusal to issue a visitation order were in the best interest of the oldest child. In this case, the lower court's findings and conclusions don't demonstrate that an adequate best interest analysis occurred, either in determining unfitness or the visitation piece. There are critical pieces of information missing.
You mean unfitness as to this child in particular?
Correct, Your Honor. First, I would mention there was no consideration of this child's age. At the time of trial, Jay was 11 years old, and she was nearing the age of 12 when her consent would be required for an adoption. The cases of adoption of Caesar and adoption of Ramona emphasize the importance of taking an older child's age into consideration in termination proceedings because of the implications that arise when a child turns 12.
If I may interrupt you just now, just to have the context for myself, am I correct that at trial, the children were presented as a block and that no separate argument was made on behalf of Jay in this respect?
Yes, this is one of the faults.
Okay. Do you think that the interests of Jay are adverse to the interests of the other children, or were at the time of trial?
Her wishes, Your Honor, and that's my second point, was about the absence of evidence of Jay's wishes at the time of trial. There was no evidence of her position at the time of trial. And while this might have otherwise resulted in a waiver, adoption of Flora says that the wishes of an older child are so crucial to a best interest analysis that lack of information warrants a remand. So here we have no evidence of her position at trial.
Do you think that the same counsel could have represented Jay and the other 5 children, or 6?
I'm not sure, Your Honor. I think remand is necessary to make detailed and specific findings that pertain to Jay. Because I feel like her argument, obviously there's numerous children.
Okay. I mean, part of the problem we have is you're telling us she had desires at the time of trial, but they don't appear on any record in front of us.
That's correct. It's the same as the situation in adoption of Flora, where there was no evidence of an older child's wishes. And in that case, the court found that the interest of the child weighed in favor of remand. And I would suggest that this case is the same.
But getting the evidence before, are you talking about getting the evidence before the judge, which was counsel's responsibility? Or are you talking about the judge not making a particular finding based on evidence that was there?
I think it's both. In adoption of Flora, it is addressed the fact that the trial counsel did not bring that evidence forward at trial, but despite that lack of evidence, the court did not waive that position on appeal. The court found that the child's interest weighed in favor of remand to make findings about the child's position.
But in this case, you're saying that the evidence was not in the record.
Correct.
Not that the judge simply failed to make findings that were there, but the evidence wasn't in the record to begin with.
That's correct. Like Flora, the evidence is not in the record, and therefore the trial judge could not make a best interest determination considering the age of this child.
And it's my understanding that this judge is retired. So when you ask for a remand, you are therefore asking for a new hearing with respect to Jay?
Correct. Another factor that the lower court ignored was Jay's significant relationship with her mother. Jay spent the overwhelming majority of her life in her mother's care. When she was removed in 2018, she was 11 years old, and she had spent approximately 10 years of her life in mother's care, and a significant relationship would have arisen from that. Additionally,
did the court ignore that, or did the court find specifically that there was no bond?
The court does not address the issue of a bond. I believe the court ignored their favorable evidence because the department's own records state that there was a clear bond between Jay and her parents. The department's own records state that described Jay as attached to her family and describes Jay's relationship to her family as appropriate. And none of this was ignored in the findings. The judge summarily concluded that there was no significant relationship between Jay and her family, her mother.
Well, are we using family and mother interchangeably? Or are we using family at one point were the kids and both parents?
I would use mother here because she is the father is not appealing to judgment. So I would say, and the judge did acknowledge that there's a significant relationship between these siblings. I think my final point I would want to make about Jing is that she's not in a pre-adoptive home. And our courts have recognized that children who are not in pre-adoptive homes are in a particularly vulnerable situation. And our courts have a heightened responsibility to protect children in this position. And that heightened responsibility should be reflected in the findings. In adoption of Ramona.
Thank you, counsel. I'm afraid your time expired.
Thank you.
But if there are other questions from the panel, or the panel wishes to hear more. All right. I believe we now turn to Attorney Campbell.
Yes. Good morning. May it please the court. My name is Alan Campbell. I represent the 6 youngest children in this matter. You will hear from me twice today. I'm here now to discuss the lone issue for which the 6 younger children are appellants, and that's that the judge abused her discretion in not awarding post-termination and post-adoption contact. Mother, father, and all of the children asked for this contact at trial. And at trial, the judge announced or denied this request, announcing there is no evidence given at trial that there was a significant relationship between any of the children and parents that, if disrupted, would cause irreparable harm to the children. That is not the legal standard. The legal standard is whether visitation is in the best interests of the children. So that's straight off the bat, that's a clear error of law. And then in her findings, she simply writes, the court declines to order post-termination and post-adoption contact and leaves it to the discretion of any eventual post-adoption resources. There is no determination of whether or not it would have been the contact would be in the children's best interests. And it's not, as DCF writes in their brief, it's not just a matter of phrasing. It's applying the wrong legal standard. The judge could have thought that visits were in the children's best interests, but that they would get over not having contact. That's not precluded by the statement of there's no bond that'll be the, and the finding wasn't that there was no bond. It was that there is no significant bond that will cause irreparable harm if it's broken. Similar sounding, but very different. And I'm not certain that a remand is necessary because this court has the authority, given this record, to order contact, and the 6 younger children would ask that it do so. It order reasonable contact, which would be at least 2 visits a year. And that's because if you go through the record, this is a 4-year-long trial that the parents visited consistently, except for a brief period following the second removal. And I don't believe there was a single incident or a single problem that was mentioned of any of the visits. Over 4 years, no problems.
Do you have authority for our court ordering visitation when that had not been done at the trial level?
Yes, any case where their visits aren't granted and the court reverses, the order is usually to have visits. Certainly,
it's not remanded for the trial court to make that determination?
Well, if the judge has made the determination that there shouldn't be visits and it's appealed and this court reverses, the only option is to have visits. So it's implicit that this court would have the authority on this record to order visits. If you don't believe that, then you could remand. Certainly at a minimum, it should be remanded for a hearing for the limited purpose of whether or not, in what extent there should be visitation, and that shouldn't slow down or hinder eventual adoptions, which I'll discuss after DCS talks. But this court certainly does have the authority, and if it's not implicit, I'm sorry I don't have a case directly on point for that. But again, any case where the court has gone through the analysis, come to a conclusion that there's visits are not allowed, there's an appeal. If this court reverses, the only thing that you can reverse, if you reverse a decision that there shouldn't be visits, you're in fact ordering visits. So this court definitely has the authority to do that. And I see my time is up.
Does the panel have any other questions? All right. Thank you. I believe we now turn to the other side of the V. Is it Attorney Campbell or Attorney Montoya, I believe?
Yes, Your Honor.
Yes, okay.
Thank you. May it please the court, my name is Roy Montoya and I represent the Department of Children and Families. I am here with the Youngest Children's Council and we've agreed to split our time 10 minutes for the department and 5 for younger children. Mother's neglect of these children was clearly and convincingly established at trial. Just starting from the second removal, Mother immediately consecutively missed 7 parent-child visits that were offered to her over the 2.5 months. That's 2.5 months where her children went back into foster care and had no idea where their mother was or how she was doing. The one thing Mother had to do to start her visits was provide a letter from her doctor clearing of her scabies infection. That was the simple task she failed to do. And when she went to the doctor, she went with Father, a man who had assaulted her in front of her children and who she was supposed to be separated from. Mother's visits at this time had been reduced to monthly. From then until trial, Mother missed 2 out of 5 offered parent-child visits. That 9 months from the second removal to the trial is a period of time in which Mother had essentially abandoned these children. During that time, Mother was difficult to reach, but the social worker was able to speak with her briefly about a month before trial. She admitted to suicidal thoughts following the second removal, but refused the social worker's offer for a therapy referral, saying she had a new man in her life who was like a therapist to her. By the time of trial, this case had been pending for about 3.5 years. About the upcoming trial, Mother said that she might not get her children back and that she was, quote, pretty okay, unquote, with that, because she did all she could and needs to live her life and be happy now. Sadly, she missed her next and final parent-child visit, and then she missed every day of trial. Mother's neglect was directly related to each individual child, just as it impacted them collectively. And what is striking from the record is that despite their mother's absence, there is no indication that these children suffered because of it. Indeed, with their mother mostly missing for the 9 months leading up to trial, they seem to have thrived in their foster homes. Jay was in swimming lessons. She was 11 at the time of trial. She was doing phenomenal when she was off of her ADHD medication, and she was now starting to strive for excellence in school because of the support of her foster mother. The 9 and 10-year-old were placed together in the same prior foster home. The 9-year-old, initial A, was described as a mild-mannered, affectionate child in his foster home. Similarly, the 10-year-old was creative, inquisitive, hardworking, and motivated student. Their foster parent providing both of them with the testing and school support they needed to succeed at the time of trial. The twins were placed together. One was described as athletic, adventurous, and smart. The other was described as well-behaved, intelligent, and very affectionate. Neither child had asked about their parents. The 6 and 4-year-olds were also placed together. The 6-year-old was described as having a huge heart, as being friendly and outgoing, and the 4-year-old was described as smart, caring, and a joy to be around. These children at the time of trial excelled. They were excelling in their foster homes despite not having seen their parents. And when we look at questions of whether the children were treated individually, they were. The judge wrote 387 individual subsidiary findings, where she very specifically applied these findings to each individual child as appropriate. She named each one throughout her findings. When we look at whether Mother was fit to one child, she was not. The 11-year-old Jay was reunified first in January of 2017. 2 months after being reunified, the father got drunk and physically assaulted Mother, was arrested outside of her home. We now look in hindsight and we know that he was in the home, but we didn't know at the time. When the 4 and 6-year-old were reunified April 5th of 2017.
If I may stop you there, with respect to Jay, what do you say to her counsel's argument that Jay is now 13 years old, will not consent to adoption, and does not want to have her parental rights terminated under those circumstances.
Well, I think the question for this court is what was decided at the time she was 11. It's not to question what is going on, what is going on with Jade now that she's 13.
Well, I think that's the reason why our cases say that when a child is that close to 12, that we're supposed to be thinking about that even when they haven't reached the magic statutory age of 12. And I don't think we can ignore the reality of what we're being told.
Yeah, I don't know that.
Do you oppose a remand as to Jay?
I do oppose a remand. The decision was supported and is appropriate, and I don't know that Jay would refuse to be adopted. We have adoption workers that work with these children. Oftentimes it comes down to identifying the resource and moving the child into the resource, and children, even teens, are looking for permanency. They're seeking that. As her siblings move into their adoptive homes and are adopted over the coming months and years, that will likely have an impact on Jay as well. There are a lot of things.
What percentage of the department's adolescents are adopted?
I don't have the percentage. But I do manage the trial caseload for the department, and there are a significant number of teens that are moved to adoptive resources, including some of Jay's siblings. So it is possible that there would be an adoptive resource for Jay, and things may change for her as time goes forward. The department has not been opposed to contact with mother for Jay. And the issue is we have a mother who is not reachable, has abandoned them, hasn't asked about them, and hasn't come forward to ask the department for contact with her children. So we're not opposed to Jay maintaining contact. We're not opposed. It's just a matter of, it comes down to mom. And at the time of trial, the judge is looking at this mom who has essentially abandoned these children. Right? Over 9 months, she's only made it to a handful of visits. She's saying that she's okay with her rights being terminated to her worker. She's okay with it. She's got to live her life now. And the judge has to take that into consideration as well in determining which is really in Jay's best interests in terms of permanency. I don't think there's a question that these children would have, preferred to have been with, parents. I think that's the presumption of the court when we start, but you have to look at all of these facts and circumstances and the seriousness of mother's unfitness to try and figure out what is the best chance at Jay finding permanency and happiness in our life. The trial court here made hundreds of findings. She focused quite heavily in many of them on Jay and on what was going on when she was with mom. She was cycling out of control. Her impulse control made her a danger in the community, I think was one.
What do you say about a judge's responsibility to consider whether a parent can handle a subset of the children versus all of the children?
I think it is important, as this judge did here, to make a determination about what's going on in the home and what the capacities were at the time, as we're going through reunification. So she did that. So here we saw Jay was the only child in the home, and we have the domestic violence between mother, father, the arrest. And then we take into consideration also the evidence we get later that shows that father was in fact in the home and the children were told to lie about it. So I agree, the judge needs to do that, and she did that here. And I also think that when you look at a lot of what was going on with mom at the time of trial, those issues with mom, her suicidal thoughts, her refusal to do therapy, her failure to visit the children, her failure to maintain contact with the department, not telling us where she was living or letting us see her home, these issues applied to each individual child. No matter which child you wanted to carve out and say, we place that child home, those issues made her clearly and convincingly unfit as to that child. And I want to say, with regard to visits, the judge did make a decision about who these children were bonded to, and they were bonded to their siblings. When she went through all of it, she was making that determination. The judge
But
on the bench.
she didn't make an explicit determination that there was no bond between the children and the mother.
She didn't. The inquiry, as stated on the bench, the issue is what did she really look at here? And she made a determination about what was in their best interest in terms of their bond, and it's their siblings. That's who they were really connected to. And the fact that mom had not been visiting them was also an important consideration in determining whether it was appropriate to order visits. And just finally, if the children today at their age, in their circumstance, want visits with mom, the department's not opposed to it. Children have an avenue. They can go to the trial court and ask the court now to order it based on their current needs. And we're not opposed to it if mother was here, but she's not anywhere in contact with the department seeking access to her children. If there are no further questions, I will rely on my brief.
Panel, anything further? Okay, thank you. Attorney Campbell.
Good afternoon again. Alan Campbell for the younger children, now representing them in their role as appellees. Except for the question of visitation that I've already addressed, the younger children ask that this court affirm the judgment affirming the termination of the parental rights and freeing them for adoption. As to the question of whether there should be a remand for Jay, the younger children take no position on that. That's entirely between DCF, the mother, and the oldest child. To answer a question that Justice Desmond asked about whether a mother's lack of contact with DCF stemmed from poverty, and I would say that it does not. On March 13, 2019, mother reported to DCF that she had received many messages from them and had decided not to return the calls or the texts. And that's in finding 290 and evidence exhibit 1 at page 92. And the judge also expressly said that this case was not being decided on the question of poverty. So I think that answers that question. There was no argument raised by mother at trial that she could parent a smaller subset of them. Again, not taking a position as to whether she could parent Jay, but the record is clear that she cannot parent any of the younger 6 children. And if you look at the most current information, which would be what she did following the second removal in November of 2018, and that was she did nothing. She was not engaged with DCF. She completed no tasks on her service plan. She essentially gave up. She did visit with the children. There was a 3-month window where she didn't visit with them following the second removal, but then she had monthly visits for, I think it was about 4 months prior to trial. And then she did not show up at trial. And as my brother indicated, there were 370 odd findings of fact going into detail for each of the children. And then in applying the statutory factors, it's very clear that mother, despite loving her children, is simply not able to care for them. And this isn't a case where she's a bad person, intentionally neglecting them, intentionally abusing them. It's not. She loves her children. That's clear. They love her. She is just simply unable to care for her children. And she repeatedly chooses partners who inflict domestic violence on her and expose her children to them. She was not able to separate from Father F early on in the case. I think it was actually the original reason for removal. There was a fight. Father F was told he couldn't be in the home. DCF told mother Father F couldn't be in the home. He left that night. And then the next day, she let him back into the home. And that continued throughout the pattern that continued throughout the case. And even at the time of the second removal, as my brother mentioned, she and her abusive partner went to a clinic to get cleared for scabies on the same day and presented that to DCF at the same day. So it's
if she's that inconsistent in her visitation, how can it be error for the judge not to order visitation?
If mother was asking for visits, you could say, no, you're not getting visits because you're not consistent. However, the children want to see mother and they should not be punished because mother is inconsistent. Again, the parents forfeited their right to visit the children, but the parents' conduct does not forfeit the children's right to know their parents. They live with their parents.
Don't the children, can't the adoptive parents do that at their discretion?
That's possible. And I mean, it could happen, yes, but it's not a guarantee that it will happen. For instance, at the time of trial, there were no pre-adoptive homes. That has changed slightly. But the record is clear that for at least 2 of the children, there's no pre-adoptive resource identified. So to rely on the possibility of a future family granting contact, that doesn't address the need that the children have to have some contact with their birth parents. And I'm not even certain that and in the interim, of course, it would be DCF that was deciding it. And DCF, although they're saying they're not opposed to it, they've opposed it. They've challenged, all 7 children have raised in their brief that we'd like to have visits, and DCF has in fact imposed it. They didn't agree there should be an order. They said, no, there doesn't need to be an order. In saying, no, there doesn't be an order suggests to me that they're not really open to it. And for mother to have to go, who's suffered for 20 odd years with DCF, to then say you have to go through DCF and hope that they give you visits, that really doesn't meet the children's needs. The children's need an order that they're allowed to see their mother. If it doesn't happen, I mean, if they have the order and it doesn't happen, that's not great, but they need to know that order, that they have a chance, that they can grow up knowing that they're going to have contact with somebody that was a part of their life. And even though these individuals can't care for them, the children do love their parents. They want to have contact with them. And the best way to do that would be an order, but now I'm switching into a rebuttal sounding, so I'll go back to
Okay.
the termination.
Well, that was my fault. I asked the question.
But I would just ask that if there is some remand, either for visitation or for Jay, that it not hinder the 6 younger children being freed for adoption, and that case be closed so that they can move forward with their lives. And with that, I'll rely on my brief for other points.
All right. Does the panel have any other questions? All right. Seeing none, I thank you all